for being here today, folks.
Of Biddeford. He was an active member of the 102nd Maine Legislature. He also ran for the United States Senate using the slogan, "Two great names, one great candidate." Thank you.
Thanks for that. Representative Wood.
Good morning. I'm Barb Wood, and I represent House District 38, which is the western end of the peninsula in Portland.
Representative Supika.
Good morning. I'm Laura Supika, and I represent District 126, which is a portion of Bangor.
Great. And my name is Louis Lucchini. I represent most of Hancock County in the Senate. Today with us, we have our committee analyst, Janet Stocco, as well as our committee clerk, Karen Montel. And we also have Representative McCrate, if you'd like to introduce yourself.
Thank you, Mr. Chair. I'm Jay McCrate, representing Harpswell, West Bath, and Northeast Brunswick in the House. Thanks.
Great. So before we get started on the hearings, we'll just go over a few of the procedures for our electronic committee meetings. Just a reminder to everybody that this meeting is currently being live streamed on the committee's YouTube channel. So this means that anyone who's a participant in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People on the Zoom meeting waiting to testify in the attendees list won't be seen or heard until we bring them into the panel to speak. And just as a reminder, when we bring you up into the panel, sometimes it may look like you're being dropped for a couple of seconds, but once you're in the panel, you can unmute yourself and turn your camera on. As always, this meeting is being live streamed for the audio on the legislature's website. And anybody who's submitted written testimony, it will be publicly posted on the legislature's website where we all can read it. Reminder regarding the chat function of the Zoom meeting, this is for technical assistance only, and it's not a place to do any substantive work. So for our bills today, we'll begin with the sponsors, followed by those who are registered to testify today, and we'll move through those in the order of those in favor, those in opposition, and lastly, those who are neither for nor against. For members of the public, when you're called upon and brought into the meeting, please remember to state your name, your place of residence, and the organization you represent, if any. And our committee also uses the 3-minute time clock. So if you can tailor your remarks accordingly, it would be greatly appreciated. Okay, so with that, we will move to the public hearings that are on the agenda this morning. We'll begin with LD 1205, an act to ensure equitable taxation of off-track betting facilities. And we'll recognize the bill's sponsor, Senator Diamond. Welcome.
Thank you very much, Senator Lucchini and Representative Chiazzo and members of the Veterans and Legal Affairs Committee. The title of the bill, as you just acknowledged, an act to ensure equitable taxation of off-track betting facilities. And that, ladies and gentlemen, is the bulk of what I know about off-track betting. So I'll be upfront with you on this, but I do have constituents that this bill means a lot to, and I was happy to submit the bill for them. My name again is Bill Diamond. I represent District 26. I live in Wyndham, and my district is Wyndham, Raymond, Casco, Standish, Baldwin, and Fry Island. This bill, the purpose of it is to cut in half the tax rate for the established off-track betting that do not receive money from the so-called slot cascade. There's similar language, I'm told, in the industries bill, which I believe is LD 1405. So for the committee, you need to know about that. And also that the tax reduction that talked about in this bill really was, I guess, and I'm told, was agreed to by harness racing interests. So I want to be sure to bring that up. And I also want to point out to the committee that evidently there's an unintended error in the drafting of the bill, and the person or persons following me will articulate that for you. So you will have everything that I know up front on this, and you'll be able to deal with it accordingly. So, Mr. Chair, that's the extent of my presentation. And I do want to acknowledge it's good to see Senator Farron working besides just Tuesdays and Thursdays.
He's a busy guy, you know. Thank you, Senator Diamond. Senator Farren.
Well, just on that piece, first of all, Senator Diamond, welcome to VLA. You caught me cheating on you with my other Democratic senator, Senator Heaney, so you got that. Also saw you made the paper in my hometown in the Morning Sentinel this morning, so the good work there. And I'm surprised that you don't know more about off-track betting, just because I do know that you like the industry overall. So thank you for bringing this forward for the folks, and thanks for being in front of VLA.
Oh, yeah, it's absolutely welcome. Thank you.
Representative Tuttle.
Senator Diamond, good to see you again. I can only reiterate what Senator Farren said about the article yesterday, Bill. I'm with you 100%. Also, I mentioned before the hearing that Plato Truman died. He was 92, and he said he had one great candidate, two great names, Bill.
Yep.
We remember him.
His son Peter served in the legislature too.
He did. Yep.
Okay, any questions for the bill sponsor at this time? All right, seeing none, thank you. Senator
Thank
Diamond.
you very much, Mr. Chairman. Thank you.
Okay, we don't have any, I don't believe we have any co-sponsors in the room to testify, so we'll move to the public hearing portion of the meeting. And we will begin with Denise Terry, and she'll be followed by Ed McCall. So welcome, Ms. Terry.
Hi. Good morning, members of the committee. My name is Denise Terry and I reside in Falmouth. I hope you will support this bill. I've worked at Scarborough Downs for 34 years, and my mother, who cannot be here today for health reasons, has owned the track since 2001. She worked hard to preserve the family business, and until the casinos cut so drastically into our revenues, my mom had turned the track into a profitable operation. When it became apparent the track could not survive against the casinos, the industry leaders asked the Downs to work to transition the live racing license to new owners committed and able to build a modern entertainment center and commercial track. We reached agreement to continue only as an OTB that would have reduced taxes shared with the balance of the industry. We need that reduction because the Downs OTB will not receive money from the Fund to Stabilize Maine's OTBs, a fund that goes only to pre-existing OTBs, and because Maine's tax rate on OTBs is so much higher than any other state. During the transition, the Downs and my family have continued to do everything we could to support the industry. The Downs conducted the majority of live racing during the pandemic. We lost money, but we believe we gave harness racing a fighting chance to survive. This tax reduction is an important part of giving our family business and our employees our own chance for survival. Thank you for your time. And if you have any questions, I'd be happy to answer them. Although I can't see you, I don't know how to make that happen.
Oh, thank you, Ms. Terry. Chairman
There we go.
Chiazza.
I can see you now.
there we go.
Thank you, Mr. Chair, and thank you, Ms. Terry, for coming before the committee today. I just wanted to acknowledge all the great work that you and your family have done for the town of Scarborough. The Downs is progressing and advancing. It's in no small part to the work you and your family have done. So thank you for that. I just wanted to acknowledge that and appreciate the work you guys are doing.
Thank you.
Great. Any other questions? Seeing none. Ms. Terry, did you submit written testimony?
I didn't. I did
Okay.
not.
Okay, thanks. All right, seeing no questions, thank you for your testimony.
Thank you.
Okay, next on the list, we have Ed McCall, and he'll be followed by Henry Jennings.
Good morning, Senator and committee members. It's a pleasure to speak very briefly this morning. And I want to thank Senator Diamond for submitting this bill for my longtime clients. I'm a lawyer in Portland, live in Cape Elizabeth, Scarborough Downs, which I've represented since 1989. year my son, also a collegiate runner, Senator, was born. I am the author of the typographical error Senator Diamond referenced. I apologize for the error. We did submit essentially the same language in the industry's version of the sports wagering bill. And there, because I had a statement of fact that I drafted, I think it was the revisor's office said, hey, you got a mistake in your bill. So they fixed it in that language in the sports wagering bill. But there should not be a reference at the bottom in the new paragraph at the bottom of section 286 sub 4, the added paragraph at the bottom, subparagraphs 1 of paragraph A and B should not be referenced. What the industry agreed to was that the Downs would benefit from a cut in its taxes that go to the others in the industry. We did not mean to speak for the state and say the state should get less. Our intention was that the state should not get less. We don't want to have a fiscal note if we could avoid a negative fiscal note. And obviously there wasn't a representative from the state at the table to talk to about the state taking a cut. So that's just a mistake on my part in sloppy drafting. I apologize for the error. My client does badly need the tax cut. And I can tell you that Denise Terry, who you just met, is working literally 7 days a week to keep this business alive, not making a profit given the high rate of taxes and the other competitive disadvantages she faces. But we're going to make it. We have some other things we hope the legislature helps us with. We really need this today. I'd be pleased to answer any questions, and I apologize for my mistake in the drafting. Thank you.
Thank you for your testimony. Any questions from the committee at this time? Okay, seeing none, thank you for coming in this morning.
Thank you, Senator.
Okay, next on our list, we have Henry Jennings. So Mr. Jennings, if you can hear us whenever you're ready, you've got the floor.
Thank you. Good morning, Senator Lucchini, Representative Chiazzo, members of the VLA. My name is Henry Jennings, and I'm currently the Executive Director for the Maine State Harness Racing Commission. The purpose of my testimony today was to be able to provide a little bit of background and information and some context to LD 1205. Denise and Ed have already alluded to a lot of what I'm going to go over, but when the Maine legislature first authorized licensing of casinos in Maine, it recognized that large out-of-state corporations would likely displace a group of historical small businesses involved in harness racing by diverting their revenue streams. Accordingly, the legislature enacted legislation intended to allow both business models to coexist by providing a small loss reduction stipend to Maine's off-track betting facilities derived from the slot revenue, or cascade as some folks refer to it. However, only those off-track betting facilities that were licensed as of 2003 were eligible for the stipend. LD 1205 recognizes that the newly licensed facility that came on board just this year will be forced to operate at an economic disadvantage. And the bill adjusts the facility tax rate in a manner that is intended to approximate the difference between not having the stipend and what they will probably receive through their wagering. So the department believes that the adjustment will improve the economic viability of the new facility. And by extension, it will also help support Maine's harness racing industry and Maine's agricultural fairs that rely very heavily upon revenue that comes from the wagering at tracks and off-track betting facilities. So that was the purpose of me trying to contribute to today's Zoom hearing. And I would be glad to answer any questions if you have any.
Great. Thank you, Director Jennings. Any questions from the committee at this time? Okay, seeing none. Thank you for your testimony this morning.
Thank you.
Okay, that concludes the people who have registered to testify on this bill. Unless there's somebody in the attendees room who'd like to, if you can raise your virtual hand. I'm not seeing anyone that's pre-registered. So with that, we will close the public hearing on LD 1205. So next bill on the list, we're going to open up the public hearing on LD 1284, an act to amend the Maine Clean Election Act and related laws. And we'll recognize the bill's sponsor, Representative Stekis. Welcome.
Trying to get everything plugged in here. Thank you.
Yeah. The floor is yours, sir.
Thanks, sir. Good morning, members of the Veteran and Legal Affairs Committee. I'm Joel Stekis, and I represent District 105, which are the towns of Canaan, Palmyra, St. Albans, Heartland, Ripley, and Cambridge on the southern frontier of the Moosehead Lakes region. I'm here today with a bill before you, LD 1284, an act to amend the Maine Clean Election Act and related laws, proposing several changes. So the bill proposes several ideas, and first off, it would change the title of the Maine Clean Election Act to the Maine Publicly Financed Election Act, and the name of the Maine Clean Election Fund to the Maine Publicly Financed Election Fund. As we all know, when submitting a bill to the revisor's office, bill title is required to reflect the content within the bill. And this is based on our own joint rule number 209 under bill titles and summaries. It says the reviser of statutes has the authority to change the title of a bill or resolve to ensure that the title accurately and concisely reflects the content and scope of the bill or resolve. The point to being accurate and concise is not necessarily for our benefit, but to be more informative and clear to the public. I think it's important for the general public to as easily as possible anyway, be able to identify government activities and general idea of what the particular activity involves. So throughout Maine and the United States, it's common practice to identify, government agencies or taxpayer-funded entities as being public, such as public safety offices or Department of Public Health, Public Education, Public Works, or even Maine Public Radio. The bill also goes on to, it removes gubernatorial candidates from public financing, which reflects the original act saving the taxpayers of Maine millions of dollars for each election cycle. It also restricts candidates seeking to participate in the Maine Publicly Financed Election Act to collecting seed money contributions from registered voters in the electoral division for the office of the candidate seeking. So principally, the principle behind taxpayer-funded campaigns is to eliminate or reduce outside influences from politics. This provision simply maintains that principle by saying that a candidate or the candidate's seed money can only come from inside their district and from the people whom they will actually directly represent. Many of you probably know there's publicly financed candidates right now that actually receive money from people outside of the state or much further than even outside of their own district. And I think that sort of contradicts what the whole idea of the act was. It also returns the amount that Maine's taxpayer-funded political campaigns get to the original Citizens Initiative proposition in 2014. Also eliminates additional qualifying contributions, since if it's returned to the original proposition, those additional contributions wouldn't be needed. Reduces the amount of funds needed to keep the program running, based on some of the things I just mentioned. Another thing it does is removes the requirement of communicating the top 3 funders, which in most cases provides no real information to the voter. And since this provision was put into place, the data program used by ethics has been greatly improved, and the information, the real information, is available there online for anybody to access. And lastly, it specifies that only party committees and political action committees and non-individuals are required to file reports with the commission based on independent expenditures that aggregate in excess of $250 during the candidate's election cycle. Very simply, this actually puts an individual unknowingly in jeopardy of violating this statute. If they simply put in a newspaper ad, or maybe they have a banner made or some other sort of communication in support of a candidate that they support, and then it ends up being $250 or more, and they're not going to know that they need to register a report or file with a government agency that in many cases they don't even know this agency exists. So eliminating that pitfall is something that we probably ought to look at. And not to mention, this provision is also impossible really to fairly and equally enforce across the state. So all of these changes may or may not appeal to the committee as a whole, but feel free to pick and choose the ones that have a consensus and move them forward in the best interest of the people of Maine. Thank you for your consideration, and if you have any questions, I'd be happy to try to answer them.
Thank you, Representative Stetkis. Any questions? Representative Corey.
Thank you, Mr. Chair. This might be a question for the chairs as well, but I noticed that we're got this scheduled for a work session this afternoon as well. When I go through the session schedule online, is that a mistake, or is that what we're doing?
We have this because a lot of it overlaps with previous bills. So we've done, our analyst has put together something. So obviously what the committee does is the decision of if you want to table it or whatever, but a lot of previous bill will kind of cover some of this. So.
Okay.
Senator Farren.
Thank you, Mr. Chair. Thank you, Representative Stetkis, for bringing this forward. As the chair just mentioned, we've heard some bills that have some of these points in there. And my question to you, and I think you said it at the end, if there are some pieces of this, which our analyst Janet does a fantastic job of laying those
He's
pieces.
awesome.
Yeah, you're okay if we find something that we can get consensus on that we don't cover somewhere else, to carve that out and use your bill as a way to do that.
Yeah, absolutely. I just thought it would make more sense to put, these several ideas into, one piece of legislation, one public hearing, as opposed to presenting 6 or 7 or 8 different bills.
Okay, thank you very much.
Thanks. And yeah, and just to follow up again on Representative Corey's issue is, we had 5, I think, scheduled last week, and then this one came out later, and there's limited, because of advertising rules, we couldn't have thrown it in on the same day. So we're working it together, but obviously it's the committee's prerogative on what to do. We didn't want to exclude it from the work sessions. Representative McCray.
Thank you, Mr. Chair. Thanks, Representative Stekis. I'm just confused about the seed money piece, restricting candidates from collecting seed money from registered voters in the district they're seeking to represent. I don't understand. Are you saying seed money should come from elsewhere out of the district and not from the district?
No, it's actually the opposite. Sorry for that confusion. Under the current program, seed money can come from basically any legal source within the United States. And I think if the whole idea behind the program is to eliminate or reduce outside influences on elected officials outside of their constituents. And I think this just completely makes sense that if we're going to go forward with if folks choose to use the program, that we stick to that principle.
Thank you. I was reading it backwards. Thanks. Appreciate it.
Okay, any other questions from the committee at this time? Okay, seeing none. Thank you, Representative Stekis.
Fantastic. Thank you.
Okay, next up, we'll go to the public hearing portion of the public testimony portion, and it looks like we have Anna Keller registered to speak.
Good morning, Senator Lucchini, Representative Cayazzo, and members of the Veterans and Legal Affairs Committee. My name's Anna Keller. I'm the Executive Director of Maine Citizens for Clean Elections and MCCE Action, and I live in Portland. I'm here today to testify in opposition to LD 1284. For over 25 years, MCCE has advocated for Maine's Clean Election Act public funding system. We were there at the start to advocate for its enactment in 1996, during the early years when participation was ramping up, when budget challenges and court decisions threatened to weaken the program, and up to today, where it is a well-established program that continues to enjoy broad support among candidates and the general public. Anti-tax activist Grover Norquist once famously said, quote, "I don't want to abolish government. I simply want to reduce it to the size where I can drag it into the bathroom and drown it in the bathtub." That sentiment came to mind as we began reading this bill. LD 1284 would completely undermine the Maine Clean Election Act, stripping it of its viability and depriving Maine people of the law that they made and which they have fought for a quarter century. The result would be a program so diminished, with participation so diluted, that it could be flushed down the drain if not drowned in the bathtub. LD 1284 does not serve the interests of candidates or the public. It lightens disclosure requirements, decreasing the transparency that voters need in order to understand who is behind campaign communications. It rolls back specific elements of the Maine Clean Election Act that citizens initiated and voters approved in 2015, elements that buttress the system in the wake of a damaging US Supreme Court decision and ensured its viability into the future. The newly configured law works well, so there's no cause to revisit these provisions. The Maine Clean Election Act, created and named by Maine people, is a point of pride for Mainers and is both well used and popular with candidates and voters. Over the years, when actual problems with clean elections have arisen, MCCE has been ready and willing to work toward pragmatic, constitutional, and fair solutions. We're happy to work with any legislator from any place, any party, any point of view who is working in good faith to improve the law. But we're not going to roll up our sleeves to parse an overt effort to gut the law. We don't expect everyone to love clean elections as much as we do. We don't expect every candidate to use it. It's a purely voluntary system. But we do expect our elected representatives to respect the will of Maine people who continue to support and work hard for this and other campaign finance laws in order to keep our democracy strong. So we respectfully ask you all to vote ought not to pass on LD 1284. Thank you for the opportunity to testify, and I'm happy to answer any questions.
Great. Thank you for your testimony. Representative Corey.
Thank you for being here today, Anna. How many candidates that are serving in elective office today use the program that we have in front of us in the Senate and the House? Do you have that number?
I know the overall percentage for this past year was 55%. I'm happy to share the full numbers. We've got a breakdown of kind of everything by party, by house, by incumbent, all of that, which I'm happy to share with the committee as soon as I get off here, pretty much, so you can have it for the work session.
So that would be 55% of everybody that actually ran for office this time around.
Yeah, and it's slightly higher when you look at the number of sitting legislators who used it. There's a slightly higher percentage there than of the total candidates that ran, but I don't want to speculate on that because I can't remember exactly what that number is.
Can I just ask one more question, Mr. Chair? What, somebody just came in the room, so I gotta pop it on. What, the last time that this was put in front of the voters, meaning sort of the expansion of the Maine Clean Election Act, what did that pass by? What was do you remember what that vote total was?
Yeah, it was 55% to 45% in 2015.
So 10% difference. Thank you.
Great. Any further questions at this time? Okay, seeing none, thank you for your testimony, Ms. Keller.
Thank you.
Okay, is there anyone else in the attendees list who wishes to testify on this bill? That's all that we have pre-registered at the moment. Okay, seeing none, I will close the public hearing on LD 1284. Okay, the third and last bill scheduled for public hearing this morning is LD 1272, an act to eliminate limits on the number of taste testing events for beer, wine, and spirits. And we will recognize the bill's sponsor, Representative Salisbury. Welcome.
Thank you, Mr. Chair. Good morning to all of you. Good morning, Senator Lucchini, Representative Chiazzo, and distinguished members of the Joint Standing Committee on Veterans and Legal Affairs. My name is Sue Salisbury, and I represent House District 35, which includes part of Westbrook. I am pleased to present LD 1272, an act to eliminate limits on the number of taste testing events for beer, wine, and spirits. There are many new learnings that have arisen from the COVID-19 pandemic. Businesses have had to change their business models on a dime and find new and innovative ways to keep their doors open. We saw an increase in curbside pickup, delivery options have skyrocketed, and drive-through business models are everywhere. However, not all businesses have been able to adapt to the changing times. The businesses that were left with few options include specialty stores that sell beer, wine, and spirits. Due to limits on numbers of patrons allowed in a store at one time, many of these stores faced a dramatic decrease in sales. Now that these stores are opening their doors again, they will begin to offer taste testing events to reintroduce customers to their products. The goal of this bill is to change the current limit of taste testing events from 15 to an unlimited amount. Thank you for your time. I hope that you will join me in sponsoring this bill. There's another person that will be providing testimony that can help answer some more specific questions that you might have. I am also happy to answer questions as well.
Great, thank you for your testimony. Representative Riley.
Hello. Hello, Representative Salisbury. Just saying hi and it's welcome to VLA, my Westbrook colleague.
All right, thank you, Representative Riley. I'm glad to be here.
Any further questions? Seeing none, thank you, Representative, for your testimony.
Thank you.
Okay, on the list to testify this morning, we have Daniel Stevenson, and he will be followed by Andrew Hackman.
Hi there, can you hear me okay?
Yep.
Great, thank you. Senator Lucchini, Representative Chiazzo, and members of the Joint Standing Committee on Veterans and Legal Affairs. The City of Westbrook is in support of LD 1272. My name is Daniel Stevenson, and I am the Economic Development Director for the City of Westbrook. The purpose of this minor amendment is to remove the current fixed number of 15 taste testing events permitted per month by agency liquor stores, retail licensees that have large and expanding inventories, and that this would allow for unlimited taste testing events per month. Bablo was consulted early in the process to avoid any unintended consequences. The rationale for the bill is to expand taste testing for agency liquor stores, retail licensees stocking large inventories, carrying at least 100 different codes of spirits, wine labels, or malt liquor. This allows the agency liquor stores and retail licensees having super inventories with the authorization from Bablo to have strictly supervised and limited tastings per month. These large businesses offer wide selections of products and special ordering that could allow for more tastings, supporting customer demand and increased sales. The amendment allows flexibility for larger beverage operations while supporting responsible, increased revenues in our local and regional economies. You know, in summary, it supports the businesses, it supports our local economies, it supports reasonable and responsible consumer expectations, can generate revenue responsibly and support our economies. I've been before this committee before in prior times with expanded liquor bills that have now become statute that have been incredibly supportive on our local economies without issue. And I see this would be any different. I am aware there has been some history with the numbers of tastings, and it continues to climb up. Now at 15, I think quite frankly, if you pick a number 16 or 17, you're always going to keep seeing the bill come back. I think it makes sense for some of these large places. They most of all have their own special tasting room. You know, it's highly supervised, and it's a great way to offer different products and sell additional products moving forward. Thank you for your time. I'm here to answer any questions you may have.
Thank you, Mr. Stevenson. Representative Corey.
Thank you, Mr. Chair. So I'm trying to sort of picture this. I live in Wyndham, so not far from Westbrook, and I've certainly popped into Martini Lane and Friendly Discount. Are those the types of places we're talking about here? Are we talking about the grocery store? I wasn't even aware that any of these places were doing tastings. Is this something that they're going to get into? Are they doing tastings right now that I don't know about? Because I might like to come.
Yeah, Representative Corey, that's a great question. I appreciate it. What I do not want to do is speak on behalf of any individual businesses here. But what I would like to say, it's meant for the larger houses like the RSVPs and the like, in the Bow Streets, what have you. Again, I'm not speaking on their behalf. But what we're finding is some of them have dedicated areas where they offer these taste testings. Now, if this bill moves through and becomes statute, I don't think you're going to see this crazy proliferation of everybody doing this. They still have to carry at least 100 labels. But what it does is it offers opportunities for, let's say someone's doing 12 or 14 or 15 a month, and they said, geez, we wanted to do the month of July. We're going to do 25 tastings, you know, of different products and what have you. I think it allows the flexibility for these large beverage houses that have a whole bunch of different labels that gets people to go in to do these different tastings before they make purchases. And in some cases, some of the purchases are very expensive bottles of, let's say, whiskey, just by way of example. So it's not designed for some of the smaller places. And also, you still need the approval through Bablo. That's in statute now. So hopefully that'll answer any questions that you might have.
Yeah, I'm just trying to figure out how it fits into Westbrook since you're the economic development director there. So,
sure.
Okay.
I can answer that. I don't know if anyone here is familiar with the Rock Road Development Project. At full build out, that'll be 2 million square feet, $600 million development project. Somewhere on that site, we'd be probably looking at that at some level.
Okay. Can I ask when Chick-fil-A is coming?
You can, and I want to be quick because I want to be. Yes, they should commence construction now. If you drive by now, they're already putting the fencing up around it, so you will see the excavators on site like within the next week, and hopefully they'll be open before the snow flies.
I'm a freak for fried chicken, and I'm sick of driving to Bangor. So, thank you.
Thank you.
Thanks. So, I guess, Mr. Stevenson. So, is this have businesses complained about this? I know we last session raised it to 15 per month per alcohol type, I think. So essentially people could have it every day, I guess.
Yeah, Senator Lucchini, I really appreciate it. One of the things that's unfortunate when it comes to our alcohol bills, and I know you've been on this committee a long time, and you've seen the progression of many of these bills, and whether it was agency liquor licenses, or we get the open container district and all of these things. One of the things I like to do in bona fide economic development is to be proactive. It's not to wait till we get all the complaints coming in and then we get a rush and we got to wait another 18 months to get a committee. Is through discussions. I'm out on the street. I talk with the business community regularly. And it's like, hey, if you had flexibility, could you do this? Would you want to do this? So to specifically answer your question, no, it's not being driven by all kinds of complaints. However, the opportunity of having this available would be appreciated by some of these larger houses. And it's a great way. So we don't, maybe next summer and then, hey, how come you can't bring the bill forward? Or you know how it works. When you put 15, you put 16, someone wants 17. You put 18, someone wants 19. I don't think, I think open it up monthly just gives the flexibility. And quite frankly, what we're finding with some of these expanded liquor laws, locally, they've just not been an issue. We don't have extra police calls. People aren't losing their liquor licenses. Bablo is not getting all these complaints. And I make sure that we reach out to Bablo and speak with them ahead of time to make sure that before we bring the committee, we try to be precise about the reason and the rationale why we're bringing these bills forward.
Great, thanks.
Thank you.
Any other questions from the committee at this time? Okay, seeing none, thank you, Mr. Stevenson.
Thank you.
Okay, next on our list, we have Andrew Hackman. Welcome.
Morning, Senator Lucchini and Representative Chiazzo, members of the Veterans and Legal Affairs Committee. My name is Andy Hackman, here on behalf of the Distilled Spirits Council. I'm a resident of Union, and we did work on LD 737 2 years ago with then Representative Stewart, now Senator Stewart, to expand tasting. We are here in support of LD 1272. The discussion around what's the right number in terms of tasting, certainly this is indeed for those specialty stores that have large volume and are able to offer such a plethora of different products. Representing the spirits industry, when we approached the committee 2 years ago, the system was quite different. Obviously, we had limits of 3 tasting events, and then there was, in essence, somewhat competition among the number of events each location could hold. We had 5. And you could only do a certain number in each particular alcohol type. So the number 15 was certainly at the direction of the committee 2 years ago when they considered this. Looking back at my testimony and the different amendments that we worked on with LD 737, I can't find an exact rationale why 15 was picked. Certainly in the 2 years since we expanded and changed the tasting law, we've not heard of any particular issue. Would certainly defer to the Bureau in terms of any enforcement issues that they've had. But as Representative Salisbury mentioned and others, each event does have to go through the approval process with Bablo to be sanctioned and to take place. So this certainly isn't opening a wild, wild west in terms of having events that are unsanctioned, unregulated, et cetera, by removing the limit. And again, in terms of going back to the testimony, the amendments that we worked on 737, other than just the fact that at one point we did have 5 tastings per category, and then you were limited to a total of 5 tastings across categories. So there was this competition. I think 15 was just picked from the standpoint of, okay, if you did 5 tastings in each category, that would put you up to 15. But other than that, I'll defer to counsel for the committee and Janet's wisdom if there was a particular rationale on why 15 was picked versus 16 to reference the previous witness. But again, appreciate the opportunity and the opportunity to have this issue before the committee again. So can answer any questions the committee might have.
Great, thank you. Any questions from the committee at this time? Okay, seeing none. Thank you, Mr. Hackman. Okay, is there anyone else who wishes to testify on this bill? Okay, seeing none, I will close the public hearing on LD 1272. Okay, so those went fast this morning. So we have a break, it looks like until 1 o'clock for when we have some bunch of work sessions from bills. Chairman Chiazzo.
Thank you, Mr. Chairman. I'll wait until you finish your announcements. I just wanted to announce for the House Dems when we caucus. So if you have other things. Okay.
Okay, yeah, I was just gonna double check with Janet if we have anything else that we need to cover this morning that I'm forgetting, like a language review or anything. Okay, cool. Great. I usually forget something. All right, Chairman Chiazzo.
Thank you, Mr. Chair. House Dems will caucus at 12:15, and we'll send the link out. So grab a bite and something to drink, do your bye breaks, and at 12:15 we'll come back and caucus before 1 o'clock. So, thank you.
All right, great. Anything else? Okay, we'll see everybody at 1 o'clock. The same link will get you back to here. So the committee will be at recess until 1 o'clock.
Thank you.
Okay, bye, Patrick.
I think 1099 which is already a jacket for the most part, so that's 1099 is that very
Tired yet, honey? You know, I'm just gonna follow you and Patrick because, you know, there's so many of these clean elections, but which one we support? We're gonna support one, right? Yeah.
I think it's 1099. Let me see. I think that's the one that was Mary Ann Ward. And it was, yeah. So I'm good with killing 1099.
Okay. I did mark that down that you said that's already in statute. I'm taking my notes.
I'll work with you. If you're good with that.
Yeah, we're not on yet. Nobody is.
Voter ID. Any three is voter ID. So that'll be on.
Yep.
And also,
So we'll say ought to pass on all of that, no matter which. Yeah, if they see how they, I know, I'd like to see how they go on it. Yeah. But if Patrick's amendment takes in all the issues that they were concerned, I want to make, no, whoops.
that you
Mary Ann, what committee room is that? Is that us or is that judiciary?
I am in VLA, so where I was sitting on the corner, they lost.
Okay.
They took down the General Bird. So now I'm sitting in front of the mirror in the fireplace.
Well, okay, now,
Little something else.
well, the chair's office is through the doors then, okay.
Yes, yep, there's the chair's office door.
Yep. Is there anybody in there?
Just Karen and I.
Okay, I think we're ready to get started with this afternoon's work sessions. So these were bills that were from last week that we heard. So we can pick up to begin for work sessions. We can, I think Janet, you had a few of them grouped together, right? 253, 557, and 1083. As well as 1099, they're all on similar topics. So we'll start on that group of 4.
Certainly, I'm just trying to make sure I can write down the attendance first.
Okay. And all of the analysis.
Nobody's square is where I expect it to
be. It changes every time, and it changes midway through, which really complicates it when we're doing introductions, especially.
I think everyone's here. All right. Sorry about that.
Yeah, and so Janet sent these by email as well last night, so everybody should have.
And just for the people watching, these are online. If you go to the committee webpage and follow through by the LD number, you'll end up on this page, and you can click on the little blue box for the bill analysis. It's good nighttime reading when you can't fall asleep. One person laughed. Okay, somebody's listening. So these bills all are variations on requirements for photographic identification for purposes of voting. They all amend Section 671 of our election laws, which is the statute establishing procedures for in-person voting on election day. And they all require that a voter provide the following photo identification to receive a ballot. So under LD 253, which is, Representative Sebra's bill, the acceptable identification would be a photographic identification document that is approved by the Secretary of State by rule, and those are routine technical rules. In LD 557 and 1083, Representative Johansson's and Representative Falkingham's bills, a voter would be able to present a current valid driver's license, a current valid non-driver ID card, a U.S. passport, military ID card, or concealed handgun permit if that permit includes a photograph. all those types of identification with a photo would be acceptable to vote in person. Both bills also provide that a photo ID issued by a college or a university in the state would not be sufficient proof of identification for voting purposes. Representative Falkingham's bill 1083 goes on to provide that if the voter doesn't have the required form of ID, that voter may request a free photographic voter ID card from the Secretary of State, and then it directs the Secretary of State to adopt rules to implement that provision of law. As Senator Lucchini mentioned, there is a related bill. I didn't put it in this bill analysis because it has many more different types of provisions in it, so I thought it needed its own document. But LD 1099, Senator Moore's bill, does also amend the same statute to provide that during in-person voting on election day, an election clerk may not accept a ballot unless the voter provides photo identification. LD 1099 does not provide the details of what photo identification is sufficient for voting purposes, however. So it treats the issue of photo ID slightly differently because the bills that are discussed in this bill analysis all require the photo ID before you get the ballot. Whereas in Senator Moore's version, it's the clerk won't take the ballot back if you don't have the photo ID. Ordinarily, I don't provide policy information from testimony, but I did want to give a little bit of the background because I wasn't sure what the Attorney General would provide as far as case analysis. And I don't know all of the different types of claims that can be raised. I sort of deferred because you all asked him to provide that information. And for some of the types of claims that people can bring and have brought in the past challenging voter ID, they involve discrimination claims or disparate impact claims on different populations. And in those kinds of cases, it really matters a balancing of what the state believes the interest is in the bill versus the impact or burden on voters. So for that purpose, I did think it was worth summarizing very, very briefly for you here that the bill's supporters assert that requiring a photo ID is a common sense measure to secure Maine's elections against potential voter fraud and increase public confidence in the integrity of the state's elections. Although Maine does have few documented cases of voter impersonation fraud in the past, the bill's supporters observe it would have been difficult to detect such fraud in the absence of a photo ID requirement. In addition, photo IDs are currently required for a multitude of other transactions in today's society, so the supporters don't view it as an overly burdensome requirement. The Maine Policy Institute did submit testimony specifically addressing the fact that LD 557 and 1083 don't allow for a college or university ID to be presented for voting purposes, and they observed that that makes sense to them because those IDs don't necessarily verify residency. And I'm going to come back to that at the end of the bill analysis because there is sort of a question in all of these bills, what precisely the ID is supposed to be proving at the polls, which is not a problematic hurdle. I just think it could be clarified. Several organizations testifying against the bills were concerned about the impact on specific groups who are more likely to lack photo IDs, including transgender Mainers, who may in fact have an ID, but approximately 25%, according to Equality Maine, may have an ID that doesn't reflect their gender identity, which could cause trouble at the polls or require them to get a new ID. There could be a disparate impact on people of color. According to several organizations, statistics across the country show that people of color are less likely to possess government-issued photo IDs than white Americans. There could be an impact on seniors. Several organizations noted that seniors may not choose to renew their driver's licenses as they age, thus perhaps leaving them without the required photo ID or transportation to secure a ride to obtain the required ID. And there is a suggestion also in several items of testimony that it may be more difficult for seniors to secure the documents required to obtain an ID from the state. And then ACLU Maine testified that individuals who are living in poverty are less likely to own a car or possess a driver's license. And it may also, due to financial reasons, be difficult for them to take time off of work, obtain the documents required to get an ID, and then get transportation to get that ID. The Attorney General testified that the bills as currently drafted might render Maine vulnerable to lawsuits under the Federal Voting Rights Act, the 14th Amendment, and the 24th Amendment. And if you don't know your amendments off the top of your head, The 24th Amendment is the prohibition on poll taxes. 14th Amendment has equal protection and due process clauses. He suggested that the state might increase its chance of prevailing in any potential lawsuit by offering a cost-free and accessible means of obtaining a photo ID, but he cautioned that the inclusion of such a provision wouldn't necessarily insulate the state from the cost of defending the lawsuit in court. Secretary of State Bellows also had some concerns about potential lawsuits against the state. She raised separately the idea that the exclusion of college IDs in the two of the bills, 557 and 1083, might be challenged on equal protection or age discrimination grounds. So the 26th Amendment is the amendment that preserves the right in all states of any individual 18 years of age or older to vote. She also raised the possibility that adding a voter ID requirement could potentially be challenged on the ground that it's adding a new qualification for voters. And she asserted that under Article 2, Section 1 of the Constitution, the only requirements to being a voter are that you have to be a citizen of the United States, a resident of Maine, and being 18 years of age or older. There were also some concerns raised in the testimony about costs and time involved with a voter ID requirement. So that first bullet point talks about the time that it might take to check in everyone against their ID, and that might increase the time it takes to vote. And if someone's ID isn't found to be sufficient, then that could increase the time if the person is required to cast either a provisional or challenged ballot. Neither of those provisions are in the current bills, but there's a possibility they come up every time this issue comes up. So people express concern about that. And there were also potential increases in staffing expenses if more municipal staff are required to administer elections. There are also potential increased state administrative expenses, including producing free non-driver ID cards under 1083 to voters who lack an ID. The secretary provided some estimates of the cost and her analysis for why she thought it was possible to estimate the cost at approximately $500,000 if everyone who needed an ID went and got one from the state, as well as a potential for increasing staffing requirements at the Bureau of Main Vehicles in the weeks leading up to an election if there's a run on the Bureau to get IDs. Also, there would be costs associated with a public outreach campaign to ensure that voters understand the ID requirements. And she provided information from a 2014 NCSL report, which is hyperlinked here, which talks about the costs of implementing voter ID. There were some more specific concerns about the way the bill was drafted, or the three bills, excuse me, are drafted. So the Maine Town and City Clerks Association requested clarification on a few topics, including what is the procedure if a voter lacks a required ID. The bills don't specify the process, whether it would be the challenge ballot process that exists under current law or a new provisional ballot process that has been included in voter ID bills introduced in Maine in the past, and which would apply when somebody appears at the polls to vote and doesn't have the ID, but is claiming to be somebody on the list of registered voters in the municipality. In addition, the Clerks Association requested clarification on whether an election official is required to compare only the name or also the residence address on the photo ID when the voter checks in to vote, so that they know precisely what it is the bill is requiring them to do. So they make sure they follow that properly. They thought it could be clarified in the legislation. The Clerks Association also noticed that, or noted for you all, that the bills create a higher threshold to prove identity and possibly residency, depending on the answer to the question above, when somebody is voting in person than is required to prove identity and residency when registering to vote. If you recall from our online voter registration bill discussion, under current law, a voter registration applicant can prove the applicant's identity and residency with a utility bill or other government or official document showing the applicant's name and address. It's not necessarily required for somebody to present a photo ID, although that is, of course, acceptable proof if somebody presents that when they register to vote. There were also several questions about why an in-person voter, but not an absentee voter, would be required to produce a photo ID. During the hearing, the Maine Policy Institute, well, I don't remember them testifying. I believe they just submitted written testimony, but I could be remembering incorrectly. In any event, in the written testimony, they proposed adding an identity requirement for absentee voters. Specifically, they suggested following the law in Georgia, which they summarized in their testimony. I had a little bit of difficulty, and I apologize, I didn't have time to reach out to them, understanding which version of the Georgia law they were discussing. But I think they were discussing the current Georgia law, which is what I summarized here. And if they mean a prior version, I apologize, but we can look at whatever version you want to, if that's the direction the committee wants to go. But under Georgia law, that's effective July of this year. In addition to signing the return envelope, an absentee voter has to disclose the voter's date of birth and driver's license or state ID number on the envelope. Or if they attest on that envelope that they don't have a driver's license or state ID number, they have to include the last 4 digits of their social security number on the return envelope with their absentee ballot. If that information isn't included, the law directs the absentee ballot to be rejected. However, the voter does have the opportunity to cure that defect within 3 days of the election by submitting an affidavit to the Board of Registrars or the absentee ballot clerk and producing the photo ID, a photo ID or a copy of a current utility bill, bank statement, government check, paycheck, or other government document showing the name and the address of the voter. So that's one option presented as a potential amendment. In addition, Representative Falkingham, who sponsored LD 1083, in his testimony, he indicated that he might prefer the creation of a new provisional ballot process for a voter who doesn't have sufficient proof of identity when voting in person, rather than employing the challenge ballot process in current Maine law. So what is the difference between the two? So challenge ballots under current Maine law, which is section 673 of the Maine Revised Statutes in Title 21A, directs that an election official or another registered voter in the municipality can challenge the right of someone to vote before they actually enter the voting booth. And they do that by submitting an affidavit under penalty of perjury, identifying their reason to challenge the voter and the personal knowledge that they have upon which they're basing their challenge. The person still is issued a ballot, however, but it has to be marked with a unique number that's also recorded on a separate certificate that memorializes the challenge. And that certificate, along with the number, is sealed in a separate envelope with a signed affidavit. So there's a way to associate the challenge with the ballot, but you can't just by looking at the ballot know who voted which way. You'd have to do some investigation. Sorry, I blew it up in case it was hard for you to see. The key difference between challenged and provisional ballots is here in bold. Under current Maine law, a challenge ballot must be counted unless the number of challenge ballots cast in the election might affect the results of that election. If that is true, if there are enough challenge ballots that the results might be affected, then the challenge certificates and affidavits have to be submitted to the Supreme Judicial Court for a determination of the ballot's validity. And then they can look at those certificates and the affidavits, decide which ballots are valid, use the numbers on their certificates to decide which ballots should be counted, and use that to decide the outcome of that election. But regardless of whether that determination occurs and whether the challenge goes to the Supreme Judicial Court, after the election is conducted under current Maine law, the Register of Voters is required to conduct a hearing to determine the qualifications of each challenge voter within a reasonable time after the election. And if the voter is deemed ineligible to vote, then the registrar has to cancel their registration in the central voter registration system. So the key takeaway is that a challenge ballot is counted automatically, and it's only investigated as far as affecting the results if there's enough challenges out there. Although in any event, the voters' qualifications are investigated after the election. It may be helpful to know that the grounds for challenging the voter are set forth in current law that I've hyperlinked there. Because a photo ID or the lack thereof is not currently required to vote, the failure to present that ID is not listed as a grounds for challenging a ballot. It's possible that the way that current law is written, you could say that somebody's failure to present an ID, if required, is any other specified violation of this title, the sort of catch-all provision for challenges. But I would recommend to you, if you want to move forward with one of these bills, to actually amend the challenge ballot statute and make it very clear if you want this to be a grounds for challenging a ballot. because clarity is always helpful, I think, in these cases. So that's the challenge ballot process. Provisional ballot process is slightly different. Under the Federal Help America Vote Act, sometimes called HAVA, a voter who appears at the voting place and declares that they're eligible to vote in the jurisdiction and that they are registered, but they don't appear on the list of eligible voters, or the election official believes they're not eligible. Those individuals have to be permitted to cast a provisional ballot. The federal law does not require election officials to count each provisional ballot. However, instead, the federal law directs that a provisional ballot must be counted if a state or local election official later determines that the voter who cast the ballot was eligible to vote. So that's an example of a provisional ballot measure. Generally speaking, provisional ballots aren't counted unless some activity occurs after the election to prove that the person was eligible to vote. So that's the difference between the two approaches. We did discuss the requirements to prove identity and residency. If you want more information, we can go back over that chart in LD 1126, but I already wrote a lot here and didn't want to waste more of your time going through it. So I'll just go through that if you request. There was a bill presented in the 128th legislature, which would have imposed a photo ID requirement, and I summarized it here. It did provide for a provisional ballot process. It did have more types of ID that were allowed. It included IDs issued by a college or university, as well as an electronic benefits transfer card. And it required the Secretary of State to report on its website the number of provisional ballots cast, accepted, and rejected. That version was the version as amended by a minority of this committee in the 128th. And it did have a fiscal note, which I thought is worth you knowing, that because of the provisional ballot process that was new and included in that bill, there was a mandate preamble added, because it would add a new requirement for local government units. And then there was a fiscal note associated with providing free state IDs to people who didn't have them, as well as programming the central voter registration system and conducting voter outreach and printing provisional ballots and affidavits. In the 129th legislature, again, there was a photo ID bill that was submitted. It was, as originally submitted, identical to what you have before you as LD 253. It was amended by a minority of the committee, and it matched, after being amended, it matched exactly LD 121. Oh, I forgot to tell you that LD 121 and LD 322, the minority reports both had a phase-in sort of alternative to providing a voter ID. So if a voter appeared at the polls and didn't have the required photo documentation, but an election worker knew them, the election worker could fill out an affidavit attesting to their identity. And that was just for the first year of implementation, sort of a way of transitioning into the new photo ID process. Other states' laws have been compiled by NCSL. They were sent to you on a separate document, and it's posted on the electronic LD file separately here. But for people who want to just look at the link is included as well. Without getting into every detail, the NCSL research reveals that as of August 2020, the laws on the books in 18 states, although they were only enforced in 17 states, but the laws on the books in 18 states required voters to produce some form of photo ID at the polls on election day, and 17 states required voters to produce identification, but it didn't necessarily have to include a photograph when they arrived at the polls on election day. So for example, the type of documents you've heard multiple times associated with voter registration, utility bills, bank statements, and vehicle registrations, for example. Of the 18 states that required a photo ID, 6 of them indicated that if you lacked the requisite ID, you would have to vote on a provisional ballot. And remember, provisional ballots aren't automatically counted. So in those 6 states, they wouldn't be counted unless you later returned to an election office and produced the required ID. The 12 other states that required a photo ID provided alternative methods for voters to verify their identity if they turned up at the polls without an ID. For example, some of the states allowed the voter to sign an affidavit attesting to their identity. Some of the states allowed an election worker to sign that affidavit. Some of them Some of the states said if you sign the envelope in which your provisional ballot is placed, we'll compare your signature, and if the signature matches, then we'll count your ballot, even though you filled it out provisionally. The constitutionality of voter ID laws has been challenged in the past, and the U.S. Supreme Court in 2008 upheld a Indiana law, which had been challenged not on discrimination claims. So discrimination claims are a whole separate matter, but that Indiana law was challenged against a claim that it impermissibly burdened the right of voters to vote under the 14th Amendment to the U.S. Constitution. That Indiana law required someone voting in person to present either an Indiana or a federal government issued photo ID. If you didn't have the ID, you could cast a provisional ballot, and your ballot would be counted if you later, within 10 days, presented the required photo ID to at a different office. Excuse me, I just lost my place. Okay. In addition, if the voter was indigent or had a religious objection to being photographed, they were permitted to cast a provisional ballot, even though they didn't have an ID. And it would be counted if they executed an affidavit at the circuit clerk's office within 10 days of the election. And in that affidavit, they either explained that they were indigent and unable to obtain proof of identity without paying a fee, or they explained about their religious objection to being photographed. Indiana also offered free photo IDs to anyone who lacked an ID. So that might look to you as internally consistent. They offered free voter IDs, but then you could be indigent and claim that you couldn't get an ID. That was based, I believe, upon the fact that you couldn't get your underlying documents without paying a fee. So even though you could get the ID for free, you didn't have the birth certificate, whatever it was required as a preliminary matter to get the ID. So the US Supreme Court in that challenge held that unlike a poll tax, which they viewed as an invidious restriction on the right to vote because it's irrelevant to a voter's qualifications, Indiana's voter ID requirement was what they called an even-handed restriction that protected the integrity and reliability of the voting process itself. The court evaluated the burden imposed on a person's right to vote and weighed it against the interests asserted by the state. The court noted that for most eligible voters who didn't have a photo ID, the burden of getting the required ID by traveling to the Bureau of Motor Vehicles and obtaining your birth certificate first and whatever documents you needed first, that burden altogether, the court did not view as substantial. There were a smaller subset of voters, however, who the court did realize had more difficulty obtaining a documentation to obtain an ID, or they might be homeless, or they might have a religious objection to being photographed. For those individuals, the court did agree that the burden was heavier, but they thought it was mitigated by the option of casting the provisional ballot and traveling to the circuit clerk's office and executing the affidavit. Weighing those burdens against the Indiana's concerns that it asserted in passing the law, which were preventing potential voter fraud and protecting public confidence in the integrity of the electoral process, the court found that both of those were valid concerns, and they amply justified the state's voter ID law. It may be helpful for you to know that there wasn't actually any voter fraud proven in the case below in Indiana. But there was some proof that the voter registration system in Indiana was full of some outdated registrations from people who had moved or people who had passed away. And there were concerns that that allowed for more voter fraud to occur without a voter ID requirement. The court did leave open the possibility that a particular voter in Indiana might be able to prove that their right to vote was impermissibly burdened. So it didn't decide it for every single individual case, but as an overall decision, they did decide that the law was constitutional. And the court did note when it was talking about the free voter ID that if there had been a fee or a tax that was imposed upon someone when they got that ID, that it could have been considered an unconstitutional poll tax. They didn't decide that it was, but they did say that that was a possibility, just so that you know that that possibility was written specifically in the decision. There have been many, many lawsuits brought across the country to all different states' voter ID laws on many different grounds. And in those cases, all of which I did not read, just so that you know, when the courts have evaluated the constitutionality of the laws, they repeatedly state over and over again that the more severe the burden is on the right to vote, the stricter the scrutiny will be applied to the state's justifications for the law. So there are several different types of provisions that can help mitigate the burden and help insulate a law from challenge. And those would be the more IDs you accept, the less of a burden is viewed on voters. In addition, in some states, they accept expired IDs for perhaps a year after the expiration. In at least one state, they said if you're over a certain age and you have an expired driver's license, as long as it hadn't expired by the time you reached that age, they would accept it. So those types of accepting more IDs are viewed favorably by the courts. In addition, providing free voter IDs for qualified voters is viewed favorably by the courts as mitigating the burden on voters. Sometimes in different states, they might actually provide free access to the underlying documents if you're going to be required to provide a birth certificate. And in other states, they still require the voter ID, but they allow you to get it just by signing an affidavit that you're the person, and then you get the ID just for voting purposes. So there are different ways that states mitigate that burden on voters. There are also provisions for reasonable impediment. This is similar to what was mentioned in Indiana. So if you don't have a photo ID and you have a reasonable impediment to getting one, for example, the religious objection, you're allowed to sign an affidavit and still vote. Those are viewed as favorable provisions by the courts because they mitigate the burden on voters, as well as the provisions that allow election officials to swear to the identity of voters. And the chart that was sent to you from NCSL shows many, many different ways that the different states approach this issue. So this is just some examples. You did request the Attorney General to provide some information on other types of legal challenges brought in other states. Many of those are discrimination-based, either that a law, for example, a North Carolina law was struck down as found to be purposefully discriminating on the basis of race. And there were some really more direct evidence than you would normally see in that case than in other cases. There have been other cases brought under the Voting Rights Act, the 14th Amendment, et cetera, where they say even though the law might not have been purposefully intended to discriminate, it has a disparate impact, and the impact is so great that it's viewed as discriminatory and viewed under the lens of those challenges. But I didn't have time to summarize all those challenges for you. If you need me to, I will look into it further. You also asked the Attorney General for information on the requirements after voting, after a person moves to Maine and registers to vote in Maine, if there's any follow-up to see if they later do other things that are required of residents, like registering their vehicle in Maine or obtaining a driver's license in Maine. And I did provide you with links to those statutes that do require within 30 days of establishing residency in Maine, you do change your motor vehicle registration and your driver's license. I didn't see a response from the AG's office yet, but it may be coming. There were some more technical and drafting issues. So if you do want to move forward with these bills, several individuals who testified seem to believe that the ID that someone presents when they vote is going to be used both to check their identity, that is their name, as well as their residency, that is the address on the ID. But as I read the bills, all of them talk about the ID being presented as proof of identity. As far as I can tell, that really is just about the name, but that is open to interpretation. So I think it might be worth, as the Town and City Clerks Association requested, some clarification on that point, what precisely it is that the election official is supposed to check on the ID before they issue the ballot. In addition, there were questions or a drafting issue arose that what happens if you don't have the photo ID. If you want the person to be able to cast a challenge ballot, I suggest you amend the challenge ballot law to make that clear. If you prefer a provisional ballot process, there are examples in past legislation we could draw from, or you could just outline it and we could draft that up for you. Excuse me, I'm losing my voice. I did have a question based upon the precise language used in LD 557 and 1083. It's clear that you need a current and valid driver's license or non-driver ID card, but the US passport, military ID, and state permit to carry a concealed handgun, the way that that phrase is written in those two bills, it doesn't look like those have to be current, so they could be expired. So that may just be something you wish to clarify if you decide to move forward with these bills. The Maine Town and City Clerks Association noticed something that I had noticed and thought I must have read it wrong. So I feel better that they brought it up too. But 1083 and 557 both provide that an identification issued by a college or university in this state is insufficient to vote, which suggests that if you have an ID card from a college or university in another state, that's just fine. I doubt that was the intent, but you might want to clarify that. As far as a drafting issue, if you do move forward with these bills, but decide not to use the challenge ballot process and instead provide for a provisional ballot so that the ballots aren't automatically counted unless the ID is later provided, then there might be a potential state mandate issue. So here's the general information on state mandates. If we go down that road, I can talk about that with a little bit more with you. Just as a general note, there's rulemaking provided for in 253. So that's the bill that says you need a photo ID document, and it's up to the Secretary of State to establish which documents are acceptable by rule. That is in unallocated language, and generally speaking, it's better to put directions about making rules in statute because they're a lot easier to find in the future. So that may be something you want to consider. It's not required, but I think it's helpful. And then also in LD 1083, there's a provision that allows someone who doesn't have a photographic ID card to get a free state ID, but it doesn't define photographic identification document. And it might be good to cross-reference the definition that's earlier in the bill so that it's clear that if you don't have the photo ID that's required to vote, then you can get a free voter ID card. It's not that maybe you have, like I have my photo ID for work. I can't, if you read the bill literally, 1083, if I had a photo ID for work, even though I couldn't use that at the polls, I wouldn't be able to get the free voter card from the Secretary of State. So that's something you might want to just cross-reference the definition to make that all very clear and internally consistent if you want to move forward with that particular bill.
Great. Thank you, Janet, for that analysis, and also for that other document that goes through state by state what each one does. It's helpful information.
That was NCSL. I did not compile that, just so you know.
You found it though. Representative Corey.
Great. That was an incredible analysis. I did some of the same stuff this weekend, and Janet and I think both looked at the same NCSL document. So with that, I've got an amendment that I'm going to propose to LD 253, and I'll sort of explain kind of like where sort of the thought behind this amendment came forward. So basically, states look at this.
Oh, sorry, do you does Janet have it? Do you want to screen share it, or do you just want to talk it through? Whatever works.
Sure, we can screen share it as soon as I talk it. Do like at least explain where the impetus of it came from. So basically, I looked at I looked at the different states. It's 18 states that don't require any verification of identity. The majority of states clearly do. Sort of that NCSL analysis kind of talks about kind of the 4 different levels of voter verification that happen kind of within these states. And this is kind of the easiest way to think about it, is think like photo ID strict, photo ID not strict, verification of identity strict, verification of identity not strict. So what that would mean is that, if it's a strict state, then, basically if you don't have the ID, they're not going to let you vote. In the not strict laws, basically if you have an ID and or you don't have the ID with you, they allow you to do 2 things, cast maybe a challenge ballot or provisional ballot, or possibly swear, to who you are, swear an affidavit. So then in the verification states, it's basically like, a long list of different documents you can show up with. In the not strict states, or in the strict states, you have to have that or else. And then in the not strict states, you can, do those other things, the provisional ballot or whatever, and still cast your vote that day. So looking at, absolutely everything that sort of Janet went over that everybody presented during that hearing. I think that the amendment that I'm about to present knocks out about, I don't know, 97% of the concerns in there. So I think that Janet could put up the amendment now and I can go through it.
Yeah, Janet, if you have the document, yeah, that'd be great.
So basically what the amendment will do is it will strike the title and it'll change the title to an act to strengthen Maine's election laws by requiring verification of identity for the purpose of voting. So in the new section, and there's kind of this voting process section of the law, what it does is it adds a proof of identity section. And what it does is it basically takes, see where it says section 112-A subsections 1 to 3 there. Basically what that is that's current Maine statute surrounding voter registration, the different documentation that you would show up in order to register to become a voter. So you would now be required to bring, anything from that long list of documentation to the voting booth with you that day or to get your ballot. If you look below at the summary, you'll actually see what that list of documentation is. And it starts with, so acceptable proof of the voter's identity if the name of the voter on the document matches the name of the voter incoming voting list. So a current and valid government issued photographic identification document, including a United States passport, military identification, driver's license, or state identification, a government issued identification document with a photograph, including but not limited to a birth certificate or social security card, or an official document, including but not limited to a document confirming eligibility terminations for public benefits, a utility bill, a bank statement, a government check, a paycheck, or other government document that shows the name and address of the voter. So basically it just, takes what we already have in law in terms of, anything somebody could potentially show up with to confirm that they are who they are. So what would then happen sort of within the amendment is that if they didn't have, these documents, and in these documents, I'm not concerned about what their address is, just that their name matches who, they are on the voting list. Of course, if they have moved, they'll, be sent to go and get a new, voter registration card, because we would do that anyways if the address didn't match up. And then Janet also added in some information about, if they were maybe changed their name because they got married or something like that, that, obviously, they would go and have to change that information with the clerk. So if they didn't bring any of these materials, with them, what I've done is I've set the very lowest bar possible. And what that would just be doing is swearing in the affidavit, under the penalty of perjury, that you are who you are. So my name is Patrick Corey. On the sheet, I did not bring my, information with me, for this reason, and that person would still be handed a ballot. It would not be a provisional ballot or anything like that. They would have their ballot. So there would be no disenfranchisement here. So what this does is it kind of moves us in the direction of voter ID. The only slight change I think that I'd want to make to the amendment that we're looking at today, and this is more up to Janet, but up where it says number 2, proof of identity, I think that we just need to probably change that word proof to maybe verification of identity, if that would be okay. And then with that, I'd like to move ought to pass as amended.
I'd second that.
Okay, so the motion is ought to pass as amended, being this document, and it's to LD 253, is that right?
LD 253, yeah.
Okay, so motion ought to pass as amended by Representative Corey and seconded by Representative Kinney. Okay, Representative Chiazzo.
Thank you, Mr. Chair, and thank you, Representative Corey, for the amendment. I just want to make sure I heard you correctly. Did you say if the voter doesn't have ID, they're going to be issued a regular ballot and not a provisional or conditional ballot? It's just the same ballot as everybody else gets.
Yes, just the same ballot as everybody else gets. I think that, the biggest thing is just, I think that we want to, move in the direction of sort of the integrity of the vote. That's what people are really concerned about right now. I looked at some polling on sort of photographic voter ID, and that's extremely popular across the country right now. I was looking at the Seltzler and Company and Grinnell poll, and that 56% favored voter ID, and then 36% said they would eliminate it. And then in a 2018 Pew Research poll, 76% favored government issued photo ID and 23% opposed. So what I'm doing here is I'm setting the lowest bar possible, for people, which would include them being issued a regular ballot.
Representative Dolph?
Mr. Chair. I just want to make and add to the whole bill, the whole voter ID issue is that I put voting like top priority for me. I've done it since I was 18 and I'm over 60. That's all. I'm not going to tell you how much over, but now we've asked for IDs to fly, now to even get our vaccines, which are very important. One important thing, one not so important thing to me, that the state has a law that you cannot buy cigarettes without an ID. So that's pretty low on the totem pole of what is necessary. But the state wants an ID to buy cigarettes for, and they have to. Rather they have no driver's license, no nothing, they have to prove that they're 18, has to have their name and their date of birth. This is what I'm told. Well, wouldn't we want that same standard to be and have to have people vote? And I would say I do. If you can't buy cigarettes without an ID, but you can go vote without one, we have a problem. And it's very important the people that are voting are who they say they are.
Okay. Representative Kinney, did you have your hand up, or sorry, I thought you did, but.
I did. I'm all set for right now, though. Thank you, Mr. Chair.
Yep. Thanks. Representative Tuttle.
Mr. Chair, you lost me on the computer. My telephone went out, my TV went out, and my phone, but now I'm back, I guess, unfortunately for the rest of you, but as a point of order, which bill are we on now?
So Representative Tuttle, we've gotten a motion of ought to pass as amended. With the amendment, I don't know if you're on when Representative Corey presented, and that amendment is attached to LD 253.
So are we only dealing with 253?
For now, yep. The amendment that was offered is to that bill. So that's where the motion is now. Yep.
All right.
Yep. Representative Corey. Oh, sorry. Are you all set, Representative Tuttle? Yep.
Thank you. I just want to make it very clear. I'm not asking for photo, ID here at all. It's again that list of different items there. I'll probably also note I think the smoking age now is 21, not 18 anymore. We changed that last year, but I just want to make very clear that we're talking about the whole long list. That's there, and and that's where I'm at. I have the bill sponsors permission to do this, so cool.
Representative Chiazzo.
Thank you, Mr. Chair. I mean, I appreciate Representative Corey's attempt at finding that compromise and threading that needle. It just strikes me if if the goal or the intent here is to verify identification, but if you don't have the identification, you're going to be allowed to vote anyway. It just strikes me that this is this creating just like a cumbersome bureaucracy without the desired outcome anyway. I mean, I don't personally believe that the identification is necessary to begin with, but if the goal is to confirm the identification, even under, the guise of perjury with a signature, I'm wondering if implementing something like this creates a burden, a lot more bureaucracy, and doesn't necessarily accomplish the goals of identity verification if that's the intent. So, but maybe I'm missing something. I don't know. That's my initial take. Just hearing the amendment as it's presented now.
I was muted that whole time. Sorry. Did you want to respond to that, Representative Corey? Or that was where it's directed? Representative, I think you're muted too now.
So I would just probably argue that it's no more bureaucratic than what we currently do with regard to voter registration, and it's probably the least bureaucratic process of I'm really bad at math. The 32 states that have some form of voter ID. This is probably the least bureaucratic of all of them.
Representative Kinney.
Thank you, Mr. Chair. Yeah, I recently, over the weekend, my hometown had our annual town meeting, and I actually brought this up prior to all of our voting with the people who were acting as ballot clerks and so forth. And they did have the concern about the senior citizen, for example, who no longer has a driver's license, and if they could bring in something like a utility bill, which they're still going to have, that would be something that they would approve. But in general, this was bipartisan at the polls in my town. They were very much in favor of the idea of doing something for voter ID, because it is difficult, even in small towns where we kind of know everybody, but we kind of don't. And as I had explained during the public hearing, in our small little town, they mess up with the junior versus the third versus the, juniors and seniors can be messed up, confused. Representative Corey mentioned it was his father and mother that got mixed up. This would simplify and give them a name to verify on that voter list. So if they misunderstood, I know I have some people in town that they have a difficulty being clear in what they're saying, and their name can come across incorrectly, and then wrong name can be checked off. And this is just to verify the integrity of a fundamental right of all citizens. And this compromise, this amendment addresses a lot of the concerns that came across from the Secretary of State, from the Attorney General, from the members of this committee. So I am hopeful that people will support this amendment.
Representative Corey.
Yeah, I mean, I would say, in terms of what happens at the polls during the day too, and all of us, because, we're a bunch of nerds that run for office, have stood out in front of the polls, for hours and hours and hours, every day. And it ebbs and flows. We all know that, people come in at 7, they're all gone by 8. People then come in at 11:30, they're gone by 12:30. And then, it trickles after that. And then again, they come in at, 4:30, and, generally that crowd ends at, 6:30. Some of the smarter candidates, not myself, only hang out in the polls during those prime hours, but they don't spend all of their time there. So I certainly think that there's probably the capacity within the polls to handle something like this. Real quick, and fine, sorry, and we've heard a lot of arguments through this entire session so far that people just aren't voting in person anymore. They're absentee voting, they're early voting in the clerk's office and everything else. So if we have fewer people showing up at the polls, that means that less of this activity would be happening than would have happened a few years ago pre pandemic. Anyways, thank you.
Yep. Any other questions or discussion at this time? It says there's a hand up. Oh, Senator Hickman. Sorry.
Thank you, Mr. Chair. I will be opposing all of these bills today, including this one. Maine and Wyoming don't agree on a whole lot, but I'm going to stand with Wyoming and hope that Maine remains a state where ID is not required to vote. Thank you.
Any other discussion? It's time. Okay, seeing none, we have a motion before us. The motion is ought to pass as amended with the amendment that Representative Corey brought to LD 253. So if people are ready for the vote, we will proceed with a roll call.
Senator Lucchini.
No.
Senator Lucchini, no. Senator Hickman.
Nay.
Senator Hickman, nay. Senator Farren.
Yay.
Senator Farren, yay. Representative Chiazzo.
No.
Representative Chiazzo, no. Representative McCrate.
No.
Representative McCrate, no. Representative Tuttle.
No.
Representative Tuttle, no. Representative Riley.
No.
Representative Riley, no. Representative Supika.
No.
Representative Supika, no. Representative Wood.
No.
Representative Wood, no. Representative Kinney.
Yay.
Representative Kinney, yay. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Yes.
Representative Corey, yes. Representative Dollop.
Yes.
Representative Dollop, yes. 8 in favor of the motion, 5 against the motion, and no one absent, Mr. Chair.
Okay, thank you, Karen. So the 5 will be in support of the ought to pass as amended, and if all 8 are good, I'm assuming is ought not to pass, then we can leave it at that, and the majority minority will switch if people are good with that. So is everybody who voted no supporting the ought not to pass? Okay, I see head. Yeah, okay. Okay, Representative Dolph, did you have a question?
No, I just hit that and now I'm trying to get rid of it. I'm sorry.
Okay, no problem. Okay, so with that, that will close the work session on LD 253. Okay, so we have other bills on this topic. So the other one we have is LD 557. Is there a motion or discussion on that? Representative Tuttle.
Sure, I move ought not to pass.
Second.
Okay, a motion of ought not to pass on LD 557 by Representative Tuttle, seconded by Senator Hickman. Okay, Representative Corey.
Thank you, Mr. Chair. I just have a general question for the committee. What do we think about getting rid of the requirements to show proof of identification prior to registering to vote?
Senator Hickman.
We don't.
Okay. Any other discussion? Okay, seeing none, we'll proceed to a vote. The motion is ought not to pass, made by Representative Tuttle, seconded by Representative Hickman. We will proceed to a roll call, if you're ready, Karen.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren.
Nay.
Senator Farren, nay. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative
Yes.
Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
No.
Representative Kinney, no. Representative Harrington.
Nay.
Representative Harrington, nay. Representative Corey.
Nay.
Representative Corey, nay. Representative Dollop.
No.
Representative Dollop, no. 8 in favor of the motion, 5 against the motion, and 0 members absent, Mr. Chair.
Okay, thank you, Karen. So the vote was 8-5, and what is the minority report? Representative Corey.
I'm going to put this out there for the minority report. I would just like to lift the exact same language from the last bill then, and we'll see if my fellow committee members would be good with that. The new amended language.
Okay, so same amendment as presented last time.
Yes.
Representative Kinney?
Yes, I would like to hear what the rest of the committee wanted to go on that. I'd be good with just ought to pass, but I'm good with ought to pass as amended as well.
Okay. And is that good with the rest of the people? Okay. Good, Representative. Okay.
So the same amendment as on 253? Okay.
Yes.
I was just making sure you didn't mean the last legislature. So
Gotcha. Representative Corey.
Okay, that's great. So ought to pass as amended using the same language that we just did on the last one. Thank you.
Okay, great. Okay, so the third bill in that segment is LD 1083. Representative Tuttle.
Thank you, Mr. Chairman. I don't have any problem voting this, but from a parliamentary procedure, adding an amendment to second bill that was defeated, I don't know from a parliamentary perspective if we can do that, having been the chair of this committee for 10 years.
Yeah, I mean, as chair, I don't see why people can't do the same amendment on multiple bills, but I think it's been done before, but I'm not 100% sure. Representative Corey.
Yeah, I would argue that if we had gotten rid of these bills, then that would matter, or combined these bills, or had they been combined in the revisor's office because they were so similar prior to us even hearing about it. Yeah, but where they're all separate bills, I think that we can treat them all separately.
Yeah, I think, as Representative Corey said, normally they would have been, or if they were similar enough, they would have been rolled into one, or one vehicle would have been chosen. Well,
Mr. Chair, I guess I'm wrong again. Right,
No.
Patrick? No.
I think there's some discretion there, so who knows what the official way is. But yeah, sometimes it's just rolled into one bill and then the rest are killed. Okay, so regarding LD 1083, is there discussion or a motion? Chairman Chiazzo.
Thank you, Mr. Chair. I move ought not to pass for 1083, excuse me.
Second, Mr. Chair.
Okay, so there's a motion of ought not to pass by Representative Chiazzo, seconded by Representative Hickman, or Senator Hickman, sorry. Any discussion on this bill? Seeing none, we will proceed to a roll call vote. Karen, if you're ready, thanks.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren.
Nay.
Senator Farren, nay. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
No.
Representative Kinney, no. Representative Harrington.
Nay.
Representative Harrington, nay. Representative Corey.
No.
Representative Corey, no. Representative Dolph.
No.
Representative Dolph, no. 8 in favor of the motion, 5 against the motion, and no members absent, Mr. Chair.
Thank you, Karen. So 8-5 again. And again, what is the minority report on this bill?
Straight ought to pass without the amendment.
Straight out to pass? Okay, is that
I'm
good
gonna-
with?
I'm going to be on my own minority report.
Okay, so if we can maybe just have a show of hands of who's good with the straight ought to pass. We have Senator Farren, Representative Harrington, Representative Kinney, Representative Dolph, and Representative Corey. What is your minority report?
The same minority report that's on the other two bills.
Gotcha.
May I just say that it's likely where there's a free voter ID in that 1083 that it'll have to be an amendment with a fiscal note. Is that okay?
That would be acceptable and understandable.
Okay. So once we get those recorded, we can move to 1099. Senator Hickman.
In regards to LD 1099, I move ought not to pass.
Second.
Okay, a motion of ought not to pass by Senator Hickman and seconded by Representative Tuttle. Is there any further discussion? We have a full analysis on this one that we haven't gone through. If committee members would like to walk through the elements of this, Janet has put something together on this, on the parts that didn't overlap with the previous.
Senator, if you wouldn't mind, I mean, Janet went through it, and it doesn't have to be, as detailed, just kind of a quick run over, but she put the time in. I'd like to hear part of it.
Yeah, I think it makes sense to go through it because this one did have a number of other provisions. Representative Corey, did you have?
Yeah, I was just going to ask if this is the one that had a lot of provisions in it that were already a part of Maine law and everything else. Okay, yeah, I mean, if Janet just wants to abbreviate that, I hate to let Janet's good work go to waste.
Agreed.
I don't mind not talking whenever you don't want me to, so don't feel bad. I'm happy to go through a little bit. You can be my guide, cut me off. We need one of those little hooks like they have on the Muppet Show. You can just pull me right off the stage.
We're still trying to figure out the clock part.
Okay, so LD 1099, I think that should be Senator Moore. Please have her forgive me. The first part of the bill, sections 1 and 2, establish that, they amend the provisional law that establishes the qualifications to vote in any election that's held in a municipality in the state. So that would apply to federal, state, county, or local elections. And under this section of the bill, a person who is incarcerated in any jail, correctional, or detention facility would not be qualified to vote. Section 2 of the bill also repeals the provisional law that establishes where your residency is while you're incarcerated, because you wouldn't be able to vote. The Attorney General and the Deputy Secretary of State in this case suggested that Article 2, Section 1 of the Maine Constitution already establishes all of the requirements to vote, which is citizenship, being above 18 years of age, and a resident of the state. And those requirements are established in the Constitution to be an elector for governor, senator, and representative to the state legislature. In addition, if you follow the Constitution through, those same qualifications apply to voting on a people's veto, a citizen's initiative, and any legislatively proposed referenda. There is information from NCSL also on the voting rights of individuals who are incarcerated or then released from incarceration. I briefly stuck that in a Word document to make it a little easier to print if you wanted to. But basically, the upshot is that in most states, you cannot vote while you are incarcerated, except in the District of Columbia, Maine, and Vermont, you may. And then every state has a different approach to what happens when you're released, if you are released from prison. Section 3 of this bill would require that the ballots for state and federal elections be prepared by the Secretary of State in paper form. So that's an amendment to Title 21A. Generally speaking, the provisions of Title 21A that govern elections apply to municipal elections, although sometimes there are slightly different requirements. And there is a provision of law governing the preparation of ballots for municipal elections. But that provision of law, which I've put over here, also very specifically requires already that the ballots have to be printed. As the Deputy Secretary of State and as noted, however, in Article 2, Section 1 of the Maine Constitution, right after these 3 dots that I excerpted in the table above, it does specifically state that the elections for state senator, state representative, and governor do have to be by written ballot. There are also several provisions of law I've noted in the right-hand side that weren't necessarily raised in the testimony, but if you read through them, when it talks about printing ballots, or excuse me, preparing ballots, it does seem to be assumed throughout that statute that the ballots will be printed out. It talks about printing and what color paper it'll be, and the way that you have to print the ballot card that will be used in a voting system. The Attorney General had some concerns about what would happen if you affirmatively require every ballot to be on paper. However, because there is a provision of the Constitution allowing voting machines to be used, and the statutes governing those voting machines right now indicate that even if you have a voting machine, there has to be a paper record of the ballots. And in addition, both the Attorney General and the Maine Town and City Clerks Association worried that the way that the bill was written, it seemed to require every single ballot be in paper no matter what. And there is a provision in law right now that allows certain voters with disabilities to use accessible voting machines. And they were concerned about the relationship between the provision of the bill and that accessible voting machine accommodation that is given to people with disabilities, and making sure that we don't let the state be vulnerable to a lawsuit under various federal laws protecting the rights of individuals with disabilities. Section 4 of the bill is photo ID. We've talked about that a lot, so I'm going to skip that unless you stop me. Section 5 of the bill would amend, again, the provision of law governing in-person voting, and it would prohibit an election clerk from accepting a ballot after the polls have closed. Several people testifying at the election pointed out that under current law, although the polls have to be closed at 8 p.m. on election day, the law does specify that the warden shall give all voters who are present at the voting place at the closing time the opportunity to vote. So this bill would be in conflict with that provision of the law, but the bill does not amend that provision. So you'd need to consider addressing that tension if you wanted to move forward with 1099. And the Attorney General suggested that if you did move forward and amend the existing law as well, so that people who hadn't yet voted at the close of the polls, there might be potential for lawsuits under the Equal Protection Clause of the 14th Amendment, because the people who had arrived in time to vote were just stuck in the line and weren't able to vote, and that might open the state up to litigation. I would point out that as I read the testimony from Senator Moore's constituent on whose behalf she's submitted this bill, it did seem to me that that testimony suggested that she was intending to apply the requirement that the ballot be received by the close of polls. She seemed to be intending to apply that really to absentee ballots. I could be wrong. That's how I interpreted her testimony. And if that is the concern that the bill wanted to address, I did want to point out that under Section 755 of Title 21A, it does state that in order to be valid, an absentee ballot must be delivered to the municipal clerk at any time before the polls are closed. So if that was the concern, that is already addressed in current law. Vote buying, Section 6 of the bill would create a new provision of the election laws prohibiting a person from purchasing a vote of any other person for money or any other thing of value. Just so you know, because there's no penalty provided specifically in that provision of the bill, the default Class E penalty for violations of Title 21A would apply. The Attorney General pointed out that there already is a Class C crime in Maine law that's called bribery in official and public political matters, which can be violated in many different ways, summed up being you can violate that law by offering money or giving money to somebody to purchase their vote, or by being a voter who accepts or solicits money as far as how your vote will be cast. So that is a Class C crime, which has stiffer penalties than the bill would provide because it would establish a new Class E crime. Several organizations testifying also noticed that there is a federal law that similarly prohibits a person from making or offering an expenditure, so that is money, for someone else to vote or not to vote, or to vote for or against any candidate. So that provision of law, which is in Title 18 of the U.S. Code, does establish up to a $5,000 criminal penalty and a 1-year imprisonment, although it can be doubled if it's a willful violation, which again is less than the Class C crime penalties that we already have in Maine law for this type of vote buying. Section 7 of the bill amends the laws governing absentee voting to provide that only a person who is unable to vote may cast an absentee ballot. And if an absentee ballot is cast, the ballot must be collected and delivered by 2 other people, both of whom must certify the collection and delivery. In her testimony, the constituent who suggested this bill to Senator Moore did recognize that there might need to be some amendments made for out-of-town and overseas citizens to make sure that there is a way for them to deliver their ballots with ease and an easier collection method. But she did want to ensure that whatever the method chosen was, that it would secure and ensure the integrity of the vote. The Attorney General pointed out the various different provisions of current law that this proposal conflicts with, because under current law, depending on how you obtain your absentee ballot, you can return it by mail, in person, or in a secured drop box. Under federal law protecting uniformed and overseas citizens, uniformed and overseas citizens do have the right to submit their absentee ballots by mail back to the state. And depending on how strictly this is interpreted, the Attorney General cautioned that it might be determined to be a violation of the Maine Constitution, which does require the legislature to provide for voting by citizens of the state who are absent, or by individuals in the armed forces, or by individuals who are physically incapacitated for reasons deemed sufficient to the legislature. The Maine Town and City Clerks Association had some worries about eliminating no excuse absentee voting, which is how they interpreted this provision, even though it doesn't actually strike those provisions of law, because they thought that no excuse absentee voting is important for voters' ease and convenience, and they were worried about the confusion this provision of law would cause and how they would administer the bill. I would note, when I read this, it must be collected and delivered by 2 other people. I find that language to be very ambiguous, so I gave you a lot of information on different ways that you might want to clarify that provision if you do want to move forward with this, because it's unclear if it's collected and delivered as it's brought to the voter or just as it's brought back to the town, and what kinds of delivery methods are allowed. It doesn't specify that it has to be in person, so can they together, these 2 persons, deliver it in the mail? I also think just at a fundamental level, I don't know how this was drafted, but it does say that it applies to anyone who's unable to vote, which doesn't actually work, I don't think, because if you can vote on your absentee ballot, you're able to vote. So it basically says you can only vote by absentee ballot if you can't vote by absentee ballot. So I think you'd need to clarify that up if you wanted that provision to apply. And then you'd just direct me, and I'd be happy to do it, to look through Title 21A if you want to go forward with this provision. Just see everywhere else that you need to amend the title to make sure it doesn't have conflicts, because I think the upshot of the testimony is it does create conflicts, but those are easy enough to get rid of. You just need to tell me what you want it to do, and we can make that happen. And we don't have any fiscal information on it, this bill, yet.
Great, thank you, Janet, for putting that together. Any questions or discussion from the committee? Senator Hickman?
Yes, thank you, Mr. Chair. I apologize for getting over my skis by making that motion before that thorough and excellent analysis of just how horrible this bill is. No, in disrespect to Senator Moore, who put it in on behalf of her constituent. We do that for our constituents all the time. The bill is a mess. That excellence analysis tells us just how much so. But the biggest part of the bill that's most repugnant to me is the bill that would repeal incarcerated people from being able to cast a vote and express their constitutional right. To think that the 2 states in the country that, by virtue of the percentage of their population, are considered the whitest, and the municipality in the country, by virtue of its population, is considered the blackest, we have in front of us an opportunity for racial unity like never before if we come together and defeat this bill. So that is what I'm hoping this committee does, is express that and vote ought not to pass. Thank you, Mr. Chair.
Senator Farren.
Well, I'd just like to offer to my good colleague from Winthrop that I am going to vote for this bill ought not to pass. However, I as you use the terms repugnant and how terrible some of these bills are, just because folks have some different views of how some of these voter laws should be realized and put forward, they don't all have a racial tone to them about where our beliefs are. And I find it a little bit that how we always bring that to the table, that's what the motivation of folks that support some of these ideas are. And so with that said, I am still voting against this bill because I do think it is not a well thought out piece of legislation, but it has nothing to do with racial motivation or anything along those lines. So thank you, Mr. Chair.
Representative Corey.
Thank you, Mr. Chair. I'm going to be voting against this bill as well. I will say, having a prison in my district, that we have had voters voting there that shouldn't actually be voting there. Within Maine statute, it does say that, you know, you vote where you lived prior to it. And, you know, I've been watching the voting list, you know, over the years, and it's getting cleaner and cleaner, but we do have, you know, voters there that are registered to vote in my district that aren't supposed to be registered in my district because that's not their home. I've seen voters take out absentee ballots from 17 Mallison Falls Road, which is the address of the prison. And I know that, you know, people probably don't understand, you know, what they're doing and everything else, but, you know, we should at least be following our laws with regard to voter registration and voting. Thank you.
Senator Farren, is that hand up from before? Sorry, yeah.
Apologize, Mr. Chair.
No problem, no problem. Any other questions or discussion on this bill? Senator Hickman.
Thank you, Mr. Chair. I think that I didn't say any other bill in front of us was horrible or had a repugnancy to it, except for this one. And I also want to make it clear that when we have an opportunity to join together around something like this and pointing out the 3 jurisdictions in the United States of America that allow incarcerated people to vote, states with the most white populations and a municipality with the blackest population, that is unity. And so there is no intention from my words to suggest that anyone here is anything other than a lawmaker with an opportunity to show a supportive unity around something this important. Thank you very much, Mr. Chair.
Okay, any further discussion or questions? Senator Farren.
Nothing to add, Mr. Chair. I just want to get the last word in.
You got it. Let's see. So I see no other hands. Oh, Representative Supika.
Yep, me too.
Oh,
It's not my intent to get the last word in, but I just wanted to thank Senator Hickman for his words there. As a new lawmaker, you know, sometimes we look to the folks who have sat here for a little while to see how these processes unfold. And I do think that this is an opportunity for us to show unity. And I wanted to thank you for your words. I thought that they were, I really appreciated them, and I thought that they were really needed for today. So thank
you. Representative Riley.
I also just want to add on to Representative Supika. Thank you, Senator Hickman, for your words.
Okay, any further discussion? Okay, seeing none, we have a motion of ought not to pass by Senator Hickman and seconded by Representative Tuttle. So seeing no further discussion, we'll proceed to a roll call vote. If you're ready, Karen.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren.
Yay.
Senator Farren, yay. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yay.
Representative Supika, yay. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney.
Yes.
Representative Kinney, yes. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolliff.
Yes.
Representative Dolliff, yes. 13 in favor of the motion, 0 against the motion, and 0 members absent, Mr. Chair.
Okay, thank you, Karen, for that. And if you say do we actually have everybody? That's good. Okay. Okay, thank you. All right, and now we've got a second kind of grouping of bills related to Clean Election Act that we wanted to get started on today. So we can dive into those once we get the votes recorded and that we're ready to shift gears. And I will say, I know these bills often do get controversial, but it's certainly not questioning anybody's motivations. I don't think anybody is. So just to be clear that we've done a good job working together, whether we agree or not on certain things. So I guess, Janet, if we can go to LD 921 is the first on this list of the next block, or unless you combined on your analysis, I can't remember.
No, I didn't.
Okay.
So for LD 921, LD 921 is an act to eliminate Maine Clean Election Act funding for candidates in gubernatorial races. The bill does what the title says that it does. I wasn't sure. It's a pretty straightforward concept, so I'm not going to go through anything, but just I laid out what the overall Clean Election Act process is for gubernatorial candidates so that you would know. I think the biggest point was the idea to save funding that can be distributed to gubernatorial candidates. So there is a chart here showing you the amount of funding that Clean Election Act candidates are eligible to receive, depending on how many qualifying contributions they obtain from unique voters across the state, because it is a statewide race. So up to $1 million total for a contested primary, with up to $2 million total for a contested general election. If they also obtain seed money contributions, they can spend up to $200,000 in seed money contributions, although those monies do not come out of the Clean Election Fund. And then because it involved money, I didn't know if you wanted just sort of a recap of the sources of funds for the Clean Election Fund, so I put those here. You can tell I'm not sure what you want me to discuss, so I'm just pointing out what's in the bill analysis, and then I'd be happy to talk about any of it that you want me to. Executive Director Jonathan Wayne did provide in his testimony an outline of the different gubernatorial candidates who participated in the Clean Election Act. And then there is a 2019 study report of the Maine Clean Election Act prepared by Ethics Commission staff that I really would commend to your reading. It gave me a lot of the information that I used for all the funding amounts throughout all the bill analyses today. It's good, helpful information. It's actually required by statute for them to prepare. So you could read the fruits of your statutory labors. And then just so that you know, in the past, in the 128th legislature, there was a similar bill that would have removed funding for gubernatorial candidates from the Maine Clean Election Act. That bill had a divided report in this committee and the minority report, which would have in fact gone forward with eliminating clean election funding, was accepted in the Senate originally, but ultimately the bill did not pass either chamber. So I'm happy to go through any of this that you want, but it seems more of a strict policy issue. So I think that's up to you all to decide.
Great. Thank you, Janet. So really this is the main key is that it eliminates the gubernatorial candidates from Clean Election Act program. Any discussion or questions for Janet? We also have Director Wayne in the attendees room, I do believe. Representative Tuttle.
Mr. Chair, I move ought not to pass.
Okay, so we have a motion ought not to pass. Is there a second?
Second.
Okay, by Representative McCrates. Okay, we have a motion ought not to pass by Representative Tuttle, seconded by Representative McCrate. I'll just, any further discussion? I'll just add from, Senator Farron, yep.
Thank you, Mr. Chair. Just going to say, I've had some concerns over the years with the whole we call clean elections, just not so much the process as the amount of money. When we put in the amount of money that we do for like our salaries that we get paid as citizen legislators, and then we wonder about, money in politics. However, in this case here, with a gubernatorial election that runs across the entire state, it could still debate about whether the money's the right amount or not, but the citizens have passed clean elections. And so I'm probably going to be reluctantly supporting this, killing this bill just because I don't know what the fix is. And that's just my 2 cents.
Yeah, and just to kind of piggyback on that, I personally have voted to suspend the program in the past, and then, we got hit right away by the people who came and brought the program back. So I'll also be supporting the ought not to pass because, I have voted to not do it for a cycle, and the people came back loud and clear on us after that. Any further discussion on this one? Okay, seeing none, we will proceed to a vote on LD 921, and the motion is ought not to pass.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman. Senator Hickman, yay. Senator Farron.
Yay.
Senator Farron, yay. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney. Representative Kinney, absent. Representative Harrington.
No.
Representative Harrington, no. Representative Corey,
Yes.
Representative Corey, yes. Representative Dolph,
Yes.
Representative Dolph, yes. 11 in favor of the motion, 1 opposed to the motion, and 1 member absent, Mr. Chair.
Great, thank you, Karen. And Representative Harrington, is your motion ought to pass?
Correct.
Great, thanks.
That would probably also be a fiscal note, but it'll be like a fiscal note of like savings probably, just so that you know. So can I make that ought to pass amended?
Yes.
Thank you.
Great. Okay, so once we get that recorded, we'll move to the next bill on our list. And the next bill is LD 929, an act to address funding for Maine clean elections.
This is where being in person would help. You'd see all the papers I have to fill out.
And I know we sometimes forget all the recording of things that you need to do.
So 929. So Representative Bradstreet's bill, an act to address funding for Maine clean elections. As background, the Maine Clean Election Act authorizes the Act's candidates who have collected the required qualifying contributions and additional qualifying contributions to receive specific amounts of campaign funding from the Maine Clean Election Fund based on whether they're part of a contested or uncontested race in a primary or general election and which office they seek. The current statutory distribution amounts were established through a Citizens Initiative in 2015. That Citizens Initiative also enacted the following provision of law, which authorizes the Ethics Commission to review and adjust these amounts every 2 years. So you can see that on December 1st of every other year, the Commission, as it said, reviews and adjusts the distribution amounts based in part on the Consumer Price Index. There's some directions about they have to round it to the nearest $25. They can't just make it like you get $1,000.33. That wouldn't be very helpful. The bill, however, would just repeal this whole section of the Maine Clean Election Act. So there wouldn't be no more review and inflation and adjustment to the distribution amounts. As a result, all future distributions of Maine Clean Election Act funds to the candidates must match the unadjusted statutory amounts first established in the 2015 Citizens Initiative. So if you look, I looked at the report I referenced earlier, the 2019 Clean Election Act study report, which was put together by the staff, as well as, well, that wouldn't have helped because 2019 was before the election, as well as all of the materials printed on the website of the Ethics Commission that discloses the current amounts of distributions. And as you can see, if you go back under the bill, if you go back and reset to the statutory amounts, for an example, in an uncontested primary for State House, it'd be $500, where it had increased by $25 in the most recent election. There are other increases, for example, in a contested primary increased by $150. If you look at all of the increases that have happened by the Ethics Commission reviewing and studying the amount, there can be up to $900 more in a contested House general election than there is under the statutory amount. The same for the state Senate. The amounts have increased over time. So for example, if you're in a contested general election for state Senate and you get all of the possible qualifying contributions and additional qualifying contributions that you can, and you get every single distribution that you can increase the amount for that general election by $3,575. So the amounts have increased over time. There hasn't been an increase in gubernatorial distribution amounts so far. So those would be the same moving forward as they were in the 2018 election. But most importantly, what these charts don't show is that in the future, the numbers could not just keep increasing or even decreasing. You would have to just stay with the statutory amounts. There were some questions presented at the public hearing to Bob Howe, the Maine Citizens for Clean Elections. First, what amount of Maine Clean Election funds were actually used by candidates in past elections? Right before the work sessions, he did send that information to Karen and to myself via email, and he did post it online through the testimony portal. And I forwarded that email along to you, and it shows some charts of the different numbers of candidates and the amount of money they spent versus how much they were able to spend. In addition, there were some questions that were raised about what happens when a clean election candidate purchases items like postage stamps or a computer tablet or something like that. And at the end of the campaign, what happens to that actual item that they bought if they haven't used it up yet. And so I did look through the Clean Election Act rules adopted by the Ethics Commission, and I conferred with the Executive Director, Jonathan Wayne, and he helped point me in the right direction. And there are specific rules that have been enacted that require candidates to liquidate any property that they have. They can't just keep it. They have to sell it at fair market value and then give the proceeds of that sale back to the Ethics Commission to put back that money back into the Clean Election Fund so that it can be used by future candidates. So those excerpts of the rules are set forth here. If you want to actually read the document, you can just click on the hyperlink. And I didn't have any technical issues that I saw with the way the bill is drafted. And we don't know what the fiscal impact yet would be, although I would suggest it would be a savings, at least as far as initially resetting the amounts for legislative races to lower amounts. It would be savings to the Clean Election Fund. It wouldn't actually change the general fund requirements for how much money is transferred every year from the general fund to the Clean Election Fund, but it would be savings to that fund.
All right, thank you, Janet. Any questions or comments from the committee? All right, well, I guess I'll go. I mean, I've participated in clean elections for each cycle, both 3 cycles that I ran, 2 successfully, 1 unsuccessfully. And I think in each time, my opponent has run traditionally, and each time we were either very close with the amount of money that we raised together, or I was outraised. But in each one of those elections, I was able to return some money as well. So while I appreciate the desire maybe to keep something set, I think the goal of clean elections, one of the primary goals, is to have a fair election and to compete with private funds. And by allowing folks like myself to say, basically, I'm funded by the people in my district, not by outside interests, I think is very powerful and helpful. And I think, if there were issues where people were abusing the system rampantly and money was just being wasted, I could understand wanting to put some restrictions on it. But I think the Ethics Commission does a great job in regulating the program. The audits are fair and random. And I think for the most part, most of us that can return funds, have the ability to return funds, always do return the funds. So I'm not quite sure if I can support limiting that. Again, not just for my personal benefit, but because I think one of the goals is to have a fair and equitable election between the two or more candidates. So having said, Representative Corey.
Yeah, I don't know if I'll be supporting this bill, because the voters had put this into law, but I don't know if there's a correlation between private donations and that raising with the consumer price index or not. I don't believe because somebody would have given $10,000 last year that all of a sudden they're going to give 10 to this year because. But I've returned a lot of clean election money in the past. Twice I've gone unopposed and returned over $8,000 or at least over $7,000 to the program each time. So yeah, I don't imagine that I'll be voting for this.
Yeah, thank you. And I didn't mean to imply that it was a tit for tat. I think we did away with that legally, where you couldn't do matching funds to keep up the pace. I just think having that base foundation number that's relatively reasonable, I think helps. right? And it helps us for planning and helps us to keep it, relatively competitive. So I didn't mean to imply that, just because my opponent was raising $20,000 or $30,000 that clean election should keep exact pace with that. That wasn't what I meant to apply at all. So, any other questions from committee? All right, we'll entertain a motion if there is one from somebody.
Chair, I move ought not to pass.
Okay, Representative Tuttle moves ought not to pass. Is there a second? Representative McCrate, I lost your video, but I see your hand.
Are you talking to me?
I am. Are you having some technical issues?
I am. I was going to make the motion, but I heard Representative Tuttle, and if nobody seconded yet, I second.
Okay, so motion by Representative Tuttle, seconded by Representative McCrate, and the motion is ought not to pass. And Karen, when you're ready, please, we can call the roll.
Senator Lucchini. We can come back to him. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren.
Nay.
Senator Farren, nay. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCrate.
Yes.
Representative McCrate, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yay.
Representative Supika, yay. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney. Representative Kinney, absent. Representative Harrington.
No.
Representative Harrington, no. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolph.
No.
Representative Dolph, no. Senator Lucchini. Senator Lucchini, absent. 8 in favor of the motion, 3 against the motion, and 2 members absent, Mr. Chair.
All right, thank you, Karen. So the motion ought not to pass is successful. The absentees will have 2 business days to cast their votes. And that will conclude the work session for LD. Yeah, go ahead, Janet, sorry.
I need to know the minority report.
Thank you, sorry. Let's see, I think
Ought to pass.
Representative Harrington, I'm sorry, go ahead.
Ought to pass.
Ought to pass, okay. Janet, would there be an amendment with the financial again?
I don't know if they do because it's a separate fund, but I think that if there's a fiscal note about savings that you'd be fine with that.
Okay.
Is that true?
Representative Harrington, I think you said you're okay with that?
Yeah.
Okay, thank you. Thank you. Representative McCrate.
I just missed the count. Could I just ask for that from Karen?
Sure. 8 in favor of the motion, 3 opposed to the motion, and 2 members absent.
You good, Jay?
Yeah, I'm having trouble with my buttons. Thank you.
Okay. No worries. All right. So I think that's, I think we're done with the work session for LD 929. And we can open up the work session for LD 930. Whenever you're ready, Janet.
So LD 930 is an act to revise reporting requirements for Maine Clean Election Act expenditures from Representative Poirier. It's a concept draft that proposes to revise the reporting requirements for expenditures in order to provide transparency on how funds are spent. At the public hearing, the sponsor proposed replacing the concept draft with an amendment that would add the phrase "and increase campaign finance transparency" to the title of the bill. And it would also amend the Clean Election Act to require that campaign finance reports filed by Clean Election Act candidates include, quote, an itemized summary of invoices in excess of $1,000. There are already some reporting and record keeping requirements in the Clean Election Act. And since the concept draft was about amending those, I thought it would be helpful for you to know that under the current law, the candidate who's a Clean Election Act candidate has to maintain the following records during the campaign and for 3 years after filing their final campaign finance report. That would include all bank statements spanning the duration of the campaign. For every expenditure over $50, there has to be a vendor invoice listing the goods or services purchased and a record proving that the vendor received payment. And for every vendor who provides staff or consulting services and is paid more than $500 in an election cycle, there has to be a contemporaneous document such as an invoice, contract, or timesheet detailing the services the vendor provided. Under the rules adopted by the Ethics Commission, they also have to maintain itemized bills for all meal expenditures exceeding $50 and records of all vehicle travel expenses paid with Clean Election Act funds. And by law, all of these records have to be made available to the Ethics Commission upon request. So that's the record keeping requirements under the Clean Election Act. In addition, there are reporting requirements. So that a candidate has to file a seed money report upon seeking certification as a candidate under the Clean Election Act. And once certified, they have to report any money collected, all campaign expenditures, obligations, refunds received, and related activities to the commission according to the procedures developed by the commission. So the law contemplates that the commission will set forth the dates and what's included in the reports. And so the Ethics Commission has adopted rules that require Clean Election Act candidates generally to comply with the campaign finance reporting requirements applicable to traditional candidates. So if you look at that, all of that together, there's the seed money report, which talks about seed money contributions and expenditures and any unspent seed money. There are a whole series of reports filed before the primary and after the primary, and then before and right after the general election. And those have to include the itemized expenditures, and all of this information, the date and purpose of the expenditure, the name and address of each payee or creditor, any refund the candidate received related to those expenditures. And then if any of the people being paid is related to the candidate, they have to disclose that relationship, and also disclose the relationship if the business being paid is owned by a relative of the candidate. There are also specified 24-hour reports that talk about itemized single expenditures over $1,000 within the 13 days before the election. So there are some additional one-time reports if there are extraordinarily large expenditures. Well, that seems like a lot of money to me. I don't run, so maybe that $1,000 isn't a lot for an election, but to me, it's a lot of money right before the election. There was an issue raised at the public hearing about pooling of funds. So committee members inquired whether the current law prohibits a group of candidates under the Clean Election Act from making payments to a single vendor, if that vendor would then pool those funds in a way that permits the vendor to use the funds from one candidate to benefit a different candidate. So current statute in the Maine Clean Election Act provides that all revenues distributed to a certified candidate from the fund must be used for campaign-related purposes. That's the key phrase, campaign-related purposes. And then the candidate or the treasurer or the candidate's campaign committee may not use those revenues for anything but campaign-related purposes. So again, that phrase. The last part of that paragraph of the statute says the commission shall publish guidelines outlining permissible campaign-related expenditures. So I spoke to the executive director and got a copy of the most recent guidelines, and those do provide, the guidelines aren't highlighted, but I figured out how you could do that. I was very proud of myself. So the guidelines do specify that Clean Election Act funds can't be used to pay a consultant, vendor, or campaign staff for anything other than campaign goods or services. It can't assist in any way the campaign of any candidate other than the campaign for whom the funds were originally designated. It can't use the funds to contribute to another candidate or to promote political or social positions or causes other than the candidate's campaign. So that's the Ethics Commission's interpretation in their guidelines of what campaign-related purposes, that was the, campaign-related purposes, that was the statutory language that they were supposed to expound upon in their guidelines. I will note, however, that under the Maine Administrative Procedure Act, the word rule is defined in that act to include the whole or any part of every agency guideline that is or is intended to be judicially enforceable and that implements, interprets, or makes specific the law administered by the agency. So although a guideline that is not a rule is not technically judicially enforceable, because if it was judicially enforceable, it's supposed to be done by rulemaking. It is important to know that when a court actually enforces the language of a statute, it will defer to agency guidelines. So what am I telling you? If you had rulemaking in the statute and you said, we want candidates to only spend funds on campaign-related purposes, and the Ethics Commission can define by rule what campaign-related purposes are, then if those pieces of information were in rules itself that had gone through the whole rulemaking process, then those themselves would be judicially enforceable. Right now, it's just the statute that is judicially enforceable, that you have to spend the funds on a campaign-related purpose. If somebody did, in fact, give money to a vendor and that vendor then spent some of that money on a different candidate, the question that a court might have if this was challenged all the way up to a court is that a campaign related purpose? So they would be interpreting that statute and applying that statute to the situation. They would look at the Ethics Commission guidelines and consider them persuasive, but they wouldn't in and of themselves be judicially enforceable. Hopefully I haven't totally confused you, but I did want to point that out as a distinction between guidelines and rulemaking, something you may or may not want to consider depending on your position on this bill. And then I didn't see any technical issues because it's just a concept draft and we don't have a fiscal impact yet determined. And for some reason, it gave you a whole blank page there. Sorry about that.
Thank you, Janet. Any questions for Janet? Representative Tuttle.
Sure, I move ought not to pass.
All right, motion is ought not to pass from Representative Tuttle. Is there a second? Representative Corey?
Oh, no, I'm not seconding that.
Okay. Is there a second?
I'll second.
Seconded by Senator Lucchini. Now discussion, Representative Corey.
Thank you, Mr. Chair. I noticed that Jonathan Wayne is in the waiting room. Is there any way we can move him over as a participant?
Yeah, did you have any specific questions for the director, or did you just
Yes,
want to see his happy face?
Yes, I have a specific question for the director. I do like him though, and I'd like to say hi, but
no worries. We're bringing him in now. Director Wayne, if you can hear us, sir.
Hi.
Thank you for being, no pun intended, but Johnny on the spot. We appreciate that. Being available.
Happy to.
Yeah, that was good of him to sit all through that and not just leave it on his screen. He could have been like off in the break room making some popcorn and completely missed us, but he was here waiting for us. so you know, one of my biggest sort of ongoing concerns, at least with the program, and I've definitely talked to Director Wayne about this, and you know, and it's in how some of these sort of these expenditures are made, that sometimes when, you know, people write big checks to ad agencies, and that's sort of like you know, a check that buys them everything, we don't actually know what they did with the money. So my concern is never really sort of this idea that they're, you know, spending more money on one candidate than another, you know, through pooled, you know, resources and stuff like that. But my real concern is that, you know, within the law itself, it talks about how things are supposed to be purchased at what the market value is for those items. And my biggest concern with when these things are done through, you know, an ad agency, and everybody is using that particular ad agency, is economy of scale. And I don't know how we figure this out, and that's why I kind of like some of the transparency in this bill. So this could be, you know, maybe a postcard that's already designed and everybody is sending out, you know, basically the same postcard with their photo and everything else on it, where if they went to a private designer, each one of those people would have had to come up with their own individual design, hiring a designer to do that, plus, you know, printing it, and they would have had their own print vendor. And then that also gets into some other economy of scale issues, like gang runs and printing, where, you know, basically to have fewer plates to go on presses. You can tell that I design for a living. Fewer plates to go on presses, that they gang run all of those different items, so they only have to create one plate. So I'm curious, sort of, I guess, from the director, you know, with regard to that economy of scale that I'm talking about, if that's actually allowed and how we monitor that.
Well, let me just share with what information is available to the public and then also available to us as the agency. Candidates, both the MCA and the traditionally financed, need to disclose the purpose of their expenditure. So they do a broad category, like they enter a broad category such as mailhouse or printing in their campaign finance reports, and then they provide an explanation of purpose, which is often just sort of a phrase, and different people do it differently in different levels of detail, but we do require some information there that's more meaningful than the expenditure type. Then Maine Clean Election Act candidates are required to keep an invoice, and we don't get the invoices ourselves unless we request them, but our auditor does request them. I see them from time to time. I see ones from a company called Spectrum that a lot of the House Republicans use, and I see ones that I occasionally see some from Frame Media, which some of the House Democratic candidates use, and they tend to be pretty itemized in the invoice. There's a lot more detail in the invoice than there is in the report. And it's really, to get to your concern, Representative Corey, it's really hard to for us to know whether candidates who use Spectrum or Frame Media, are they getting some sort of economy of scale discount. We haven't studied it. We're not experts on mailhouse or printing services, so we don't know if they're getting fewer, sort of a lower cost or not. But candidates are, if an individual candidate, if a vendor gives a candidate a discount, whether MCA or TF, that is generally available to their customers, like I think the rule says non-political customers, then it's not an in-kind contribution. But if a vendor were to give a contribution to a candidate, a discount to a candidate for the purpose of helping them afford more things, and that discount wasn't generally available, I believe that would be an in-kind contribution under our rules and not allowed. But it's hard for us to know if it's happening or not.
So just to follow up on that, so that, basically, and it's funny because, when I started running, I'd make sure, because, I have vendors that I use as a graphic designers, and they would give me my graphic designer price. And I'm like, no, you absolutely have to give me the market rate. You know what I mean? So that if I ever get audited on this, I have to do it correctly. But with these candidates that are using, these services, we don't know whether or not they're paying the market rate or not, other than that's the rate they've charged other customers.
Correct. I mean, we don't know that they are receiving any kind of a lower price, and we don't know whether they are or they're not. We're just not sure.
Okay, thank you.
Yeah.
Representative Harrington.
I'm learning from the sponsor. She's requesting that we table this, so I would make that motion.
I'll second that.
Okay, we have a motion to table by Representative Harrington and seconded by Representative Dolph. So Karen, if you're available, we will take a roll call. Oh, thanks. The motion is the table.
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren.
Yay.
Senator Farren, yay. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney. Representative Kinney absent. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolph.
Yes.
Representative Dolph, yes. 11 in favor of the motion, 0 against motion, and 1 member absent, Mr. Chair.
Great, thank you, Karen. So unanimously we'll table that, so we'll come back to it, which I think is good because I didn't really know what the goal was. Representative Wood, did you have your hand up? Yeah.
I just wondered, could Karen repeat that count again? Because I didn't think it added up right, but.
I think it was 11-0.
I think Representative Wood might be right. It's actually 12 in favor of the motion.
Okay,
0
sorry.
against the motion and 1 member absent. Thank you for keeping me straight, Representative Wood. Sorry about that.
No problem.
That's what EUT will get for you.
HPER, right? Bob, yep. No.
Okay, the next bill on our list, we've got LD 981, an act to strengthen the integrity of the Maine Clean Election Act by limiting the amount of money paid to political operatives. So Janet?
Muted.
Yep, there you go.
So LD 981, Representative Morris's bill would change the laws governing Maine Clean Election Act candidates as follows. So first, in Bill Section 2, it would require the candidate to pay an employee, consultant, or any other individual who provides services to the campaign, which I believe are supposed to be distinguished from a person who provides goods to the campaign. So anyone who provides services would have to be paid on an hourly basis. Also under Section 2 of the bill, it would prohibit a legislative candidate under the Clean Election Act from paying more than the following to a single individual who provides those services. So if the candidate is a Senate candidate, they can pay no more than $7,500 to a single individual. And if they're a House candidate, they can pay no more than $2,500 to the single individual. And I didn't write that down, but that's during a single election cycle. There are no prohibitions on the amount of money for services paid by a gubernatorial candidate. There is an exception to this single individual payment cap, however. So a candidate may pay an individual who provides professional marketing services, which are defined as audio, video, and graphic advertising production services. So those individuals can be paid on a non-hourly basis and without being restricted to the maximum payment amounts listed above. The bill also in Section 4 has some record keeping requirements requiring the candidate or the candidate's treasurer to keep the following records of payments for services to the campaign. So for each individual who provides services other than professional marketing services, there would have to be an hourly time log specifying in detail the services that individual provided to the campaign. If there's an individual who provides professional marketing services, there would have to be an invoice or contract specifying in detail the compensation paid to and professional marketing services provided by that individual. And then for each non-individual vendor who is paid more than $500 for any services, sorry, the word is missing there, there would need to be an invoice or contract specifying in detail the compensation paid to and services provided by the vendor. Section 3 of the bill also requires that the hourly time logs maintained for each individual who provides services that are not professional marketing services to the campaign. So those hourly time logs under Section 3 of the bill have to be submitted to the Ethics Commission as part of all required campaign finance reports. So we've talked about this a little bit in the last bill. So there are record-keeping requirements under current law under the Clean Election Act, including the candidate keeping bank statements, keeping expenditure invoices for every expenditure over $50. And then for anyone who provides services of more than $500 in election cycle, there needs to be a contemporaneous document like an invoice, contract, or timesheet So this is the provision amended in the bill to require hourly time logs if you're an individual who's providing services that aren't professional marketing services. In addition, there are the rules require additional record keeping, including for meal expenditures and travel expenditures that we talked about before. And copies of all of these records have to be made available to the Ethics Commission upon request. So at the public hearing, the sponsor proposed amending the bill to eliminate the requirement that the candidates include the hourly time logs in their campaign finance reports, and instead just make those hourly time logs available upon request. As I mentioned before, under current law, all of the records that are required to be kept have to be made available to the Ethics Commission upon request. So if you do like this proposal from the sponsor, you would just strike Section 3 of the bill, and that would accomplish those goals. During the hearing, Representative Kinney suggested that the committee consider amending the bill to prohibit candidates who are certified under the Act from paying for services. So the caps that are established in the bill are $7,500 for a Senate candidate as a total amount that they can pay to any one individual for services, and $2,500 that a House candidate can pay to any one individual for services. And Representative Kinney suggested making those maximum caps that they can pay in total to all individuals who provide services as opposed to goods to their campaign. And there was a question that arose whether the bill as it's drafted would prohibit Clean Election Act candidates from making mileage reimbursements payments to an individual who provides services to the campaign. So as I read the bill, if the individual also receives compensation for providing campaign services, then an argument could be made that mileage reimbursement violates the requirement that the individual is paid on an hourly basis. That's not fatal to the idea, however. It's just important that the committee be clear about whether they want mileage reimbursement to be allowed or not allowed, and we can of course draft the amendment to the bill accordingly. So I don't think it's necessarily allowed under the bill as drafted, but it absolutely could be clarified. You just need to direct me to draft it that way. And then I didn't see any technical issues with the way the bill is drafted, of course, depending on what you want it to do. And then the fiscal impact is not yet determined.
Thank you, Janet. Representative Corey.
Thank you, Mr. Chair. So I guess there's kind of two questions here. Number one, like, does the Maine Clean Election Act specify in any ways that when we start talking about hourly services, and I don't know enough about labor law and everything else, do we have to at least minimally pay somebody whatever the minimum wage is for doing campaign work? Or are these people considered as like private consultants or something?
We can bring in Director Wayne. He's already in here. If you're available, Director Wayne, to help address some of these issues. So I don't know if you heard the question, if there's any requirement on hourly pay for services.
You know, I'm not an expert on the minimum wage, and I apologize. There's nothing in the election law that indicates whether there's a minimum rate of compensation or not. I would say that, you know, most of these people are not employees of, if for what it's worth, they're not employees of the candidate. They're people who are acting as on an independent contractor basis. I actually don't know the answer to that, but there's nothing in our laws or rules that really addresses it. And people are free.
The other thing that
I'm sorry, I'll withdraw that. Thank you.
So then the other thing I'm curious about is, so what if like somebody hires somebody like, you know, my friend is really good at, you know, X, and I need this person to come and consult, and they charge $2,500 for 2 hours. Would that be sort of acceptable within, you know, MCEA?
We always encourage candidates to show economy and think about the fact that these are public funds that they're spending. And we do review every single expenditure that's in a campaign finance report. And of course, we don't necessarily know the full extent of the services that have been provided. So we don't see fees that we think are outrageously high. I mean, I just can't think of anything recently along those lines. But having said that, yes, if somebody does something for a living and they charge a very high rate, and that's who the Maine Clean Election Act candidate wants to contract with, they could pay that person. Of course, I think that the scarcity of the funds, the fact that they only receive so much and that it's a lot of work to qualify for these supplemental payments, I think that results in a kind of economy that people just don't want to waste their money because they're there, they only have a limited amount of money and they want to win. So I think that helps, keep the prices affordable.
I mean, that would be if you believed every candidate really wanted to win. But what I'm getting at is that there's no maximum, right, to what you can pay somebody using Maine Clean Election Act money.
That's correct.
Per hour.
We really hope that the incentives are there, the scarcity of funds, the wanting to win, the fact that these are public funds, the fact that these are people who want to serve in the legislature. We really are hopeful that all of those factors lead to judicious decision making by the candidates, and so there are no limits.
Okay, thank you, Mr. Wynn.
So Director, so this is, I guess, just trying to figure out what it's trying to get at. This would be trying to get at people who are just hired to consult, basically, because it seems to have an exemption for people who produce mail and stuff like that, or ads.
Right. Well, I hate to speak for the sponsor, particularly if he was available, but I did talk. He was nice enough to talk to me the day before your public hearing, and he said that, he wants to. What I took from the conversation was that he was bothered that in some cases that he was aware, sort of the Maine Clean Election Act program was getting away from sort of a grassroots tradition in Maine of sort of relying on volunteers, and he objected to some situations where people were paid some large fees to provide campaign management services to candidates. That was his perception. And I'm just relating to you what he said to me. That was part of what he was trying to get at with this. So the bill places a maximum on the overall fees that a candidate could pay to any individual. That's how we read the bill. That's the $2,500 limit for House candidates and the $7,500 limit for the Senate candidates. But the bill creates an exemption for people who are producing, designing audio, video, and graphic advertising. So he said to me, I apologize for the long answer. I'm just trying to give you the full.
No,
scope.
sorry, I didn't try to put you on the spot for.
No, that's fine. He wants he thought it was what I understood.
John, he did too. Don't let him get away with that.
Okay, was that he wanted to create an exception for people who provide these kinds of professional services, creating communications. He did not want to see those caps apply to those individuals. So that's what I understand it. But there's also it changes how much detail it requires going to an hourly basis, pretty much for any time an individual is being paid to provide services, except for these professional marketing services. And the number of hours would actually have to be, I understood from the sponsor that he wanted the number of hours to be in the report, but I gather maybe the way it's written, it's being interpreted to mean the logs would actually be submitted to us at the time the financial reports are made.
Right. And sorry, I wasn't trying to put you on the spot.
No, that's fine.
Do we get a lot of people who pay like consultants just to, I guess, advise? I don't really know. Yeah.
I don't know. I can say that one of my colleagues, in response to seeing this bill, went through all of the payments, did a sort of a master report of all of the payments by Maine Clean Election Act candidates and broke it down to those who were paid to individuals. And we found one Senate candidate and one House candidate in 2020, last year, that exceeded these two limits. So I don't know if that's representative of every year. Occasionally we'll see eye-popping amounts. And we think, well, does this look right and stuff? But we don't see a lot of it.
Right. Okay. Thanks, Director. Senator Hickman.
Yeah, thank you, Mr. Chair. As the chair of the Labor Committee, I can say that wage and labor laws are all regulated by federal and state statute. And it doesn't matter the industry. The only industry where minimum wage does not apply to someone who has an employee relationship with their employer is if you are a domestic or a farm worker. That's by federal and state law. If you are hired by a campaign as an employee, you have to comply with minimum wage laws, including overtime. So what that means to me is that the provision in this law that would limit how much a person can be paid actually runs afoul of the federal and the state laws around labor and wages. So a consultant, on the other hand, has a different relationship with their employer, and they're not their employer, they're the person that they are contracting with to provide a service. So if a campaign does not have a payroll, but instead hires consultants to do the work of the campaign, whatever agreement they have between themselves as independent contractors, even under a clean elections program, is between them. As soon as the state interferes in that relationship for any reason whatsoever, you open the door to all sorts of private rights of action because you can't tell somebody what they can charge for their services.
Thank you, Senator Hickman. Representative Chiazzo.
Thank you, Mr. Chair. A question for Director Wayne. If you can pop back on, sir. Thank you. So I've never been able to afford a consultant on a House race. I'm usually trying to rub two nickels together to get the rest of my campaign materials together. But I guess I would question, you know, if I were to engage in a consultant and use, let's say, 80% of my available funds or something, might that trigger some kind of audit or some kind of flag with ethics to want to look into the campaign finances itself?
Yes, it would. And that could come about two ways. When we review the campaign finance reports, we do look at every single expenditure by every Maine Clean Election Act candidate, and we feel at liberty to ask for people's documentation. So that could trigger an inquiry from us. And then also the audit, if they're selected for an audit, that there'd be an even higher level of scrutiny by our auditor. But what I would say is that we're not that quick to cast judgments on exorbitant rates. I mean, we accept a wide range. We don't see that many causes for concern, to be honest. Mm-hmm. So yeah.
Thank you.
Yeah. Representative Corey.
Thank you. So thank you, Senator Hickman, for sort of providing some clarity to how sort of this kind of works with regard to salaries and consultants and everything else. So when I look at the bill and I look at where it talks about expenditures for salaries and professional services, those seem to be really two separate things. It seems like, you know, I guess if somebody's salaried, then they're not paid hourly, but we're talking about, you know, paying them in the bill on an hourly basis. So are we really, I guess I'd have to better understand the law, but are we paying people on an hourly basis if they're technically salaried, you know, within the bill, number one? Or number two, is it safest just to keep these people as, you know, private contractors, as, you know, and then just limit, you know, how much you can pay for them if they're a Senate candidate or a House candidate? You know, I'll be honest, I'm not going to, you know, support the ought not to pass motion. And I'm kind of working my way, I think, through, you know, what an amended version of this bill would look like. But I don't know if we can say somebody's a salaried employee and at the same time say that we need to, pay them on an hourly basis, in which case I'd probably be interested in striking that section of the bill.
I think at this point, there's been no motion, just so you know.
I thought John moved a motion right at the beginning. Representative Tuttle. He's quick with those motions.
He is very quick, but I don't think he has. He may be about to do it, but.
Well, I am. Patrick, thank you for doing that. You encouraged me to vote.
So at the moment, though, okay, at the moment, we don't have a motion, but we do now have a.
But you have a motion now, Mr.
Maybe
Chair.
that's something. Maybe that's something that that Janet could kind of answer
what is
for
something?
me, or meaning with regard to this whole salaried versus hourly, part of the bills, and if that language is actually in conflict with regard to how we pay somebody that's on a campaign.
I don't know how people pay on campaigns, so I couldn't answer that. I think it says you have to pay them hourly. So if you hire them and you execute a contract that says they're paid salary, I don't think that matches. You could ask the director if he would find ways that could be done, but I'm a literalist and I view hourly as hourly. So, but I don't have any even small, tiny tangential experience with a campaign. So I don't honestly know how that works.
We can bring in Director Wayne probably to better answer how the salary stuff works or hourly. So Director Wayne, did you hear Representative Corey's question?
Actually, I apologize. I was looking at the next bill that's on for a work session and I missed the question. I have to be honest. So if I could hear the question again, I'd appreciate it.
Yeah, Representative Corey, can you?
Oh, geez, I'm gonna ramble through this again for another 5 minutes.
Maybe just really briefly.
Okay, so here's the interesting thing about the bill, Director Wayne, is that basically, within the bill, it talks about expenditures for salaries and professional services, right? And basically, like we were talking about earlier, it limits it at $7,500 for the Senate candidate, $2,500 for a House candidate. But it gets really interesting. It asks us to report this stuff on an hourly basis. But and Janet had weighed in on this a little bit, saying that basically she would look at it literally the way it's written. But when we're talking about salarying somebody, is that in conflict with paying somebody on an hourly basis?
Well, the way I would typically use the terminology, yeah, it's a when people are paid. Well, I don't know. I know that state employees, when we hire people, the compensation is broken down by on an hourly basis and an annual basis. So I think that the purpose is to actually move everyone other than these people who are providing the professional marketing services to an hourly basis. That is, the way I read that is the candidate and the individual would have to come up with an hourly rate, and that would be the basis for the compensation, except for the marketing people who prepare these communications.
Are you aware of anybody ever actually, I mean, it could just be a language issue here, but are you aware of a campaign actually ever hiring somebody, or to just that, that person is a private contractor every time? Like they're not actually an employee of the campaign? Yes, sir.
Well, that's not really disclosed to us, but no, I actually do think that I would suspect it's very rare for a Senate or a House candidate to ever hire someone as an employee. I have heard of situations where a gubernatorial campaign does hire someone as an employee and goes through all the labor practices and requirements that Senator Hickman referred to. But at the legislative level, I think that's pretty rare, if maybe to the point of, almost never.
Okay, that answers a lot right there.
Thanks, Director. And anytime people or it seems like I hadn't heard frequently about people being hired as employees or staff or whatever and paid a lump sum, other than the governor's race. Generally, that's where I tend to hear the most complaints, and oddly, that's not even included in this bill, I don't believe. I think that's where you typically run into employees. Is that accurate, do you think? Or
I
it's
think,
obviously a much larger campaign.
yeah, I mean, we will see Senate campaigns. I may not be the best person on our staff to ask, actually, but we will see Senate campaigns that hire someone for a fair amount of services, and then we'll just pay them a flat amount like $500 or $1,000, which is a relatively high amount, I would like to say. So we do see some flat fee paying for a larger number of services, but I think it's really only the gubernatorial campaigns that actually hire someone as an employee rather than as an independent contractor.
Right.
Yeah.
And just to kind of walk through how it would work, like if I hired somebody like a firm and they were going to do some Facebook ads and some mail, I actually and hire sub vendors for that. I would actually report it as paying the sub vendors. Is that right? In the
That's right.
In the ethics rules, that way it shows where the money actually goes rather than that one person.
That's correct. And if I could just add one thing, the way I read this bill, this really relates only to how MCA candidates hire individuals, and it does not apply to how MCA candidates pay firms or document payments to firms. It's really just about paying someone who's an individual.
Okay, that helps. Yeah, I was trying to figure out exactly who this would affect. Thanks. Senator Hickman.
Thank you, Mr. Chair. So I don't want to speak incorrectly about wage and labor laws. And so I think that some of what Representative Corey is asking would probably be best answered by someone from the Department of Labor. But what I do know is what this bill seeks to do, in my opinion, is tell a private entity how it must pay its workers. And I'm not sure that that would stand up to constitutional muster, because even though this is a government program in the sense that it has rules, the entity that is a campaign is a private entity. It's not an entity that is controlled by the government. It's a private entity. And so this bill seeks to tell a private entity how it must pay someone that it seeks to employ or get services from. And I'm just not sure that that's constitutional. So I do think that if we were to go forward with this bill as written, we need to hear either from both the Attorney General and the Department of Labor. But it seems odd to me that we could tell a private entity how it must hire its employees outside of what is already in wage and labor laws.
Okay, Representative Corey.
Representative Ciazzo had the hand up before I did, so.
I'll defer Representative Corey, please. Go ahead.
I'd like to motion to table.
Great. I think Representative Ciazzo was going to do the same thing. Great minds think alike.
That's why I was going to let him talk first, so that if he needed to talk.
I think you both were
thinking. That's why I deferred back.
Mr. Chair, I withdraw my motion to not to pass that.
There was no second. So a motion to table by Representative Corey and seconded by Representative Ciazzo. Karen, would you please call the roll?
Senator Lucchini.
Yes.
Senator Lucchini, yes. Senator Hickman.
Yes.
Senator Hickman, yes. Senator Farren.
Yes.
Senator Farren, yes. Representative Ciazzo.
Yes.
Representative Ciazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley. Representative Riley, absent. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney. Representative Kinney, absent. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Yes.
Representative Corey, yes. And Representative Dollop.
Yes.
Representative Dollop, yes. 11 in favor of the motion, 0 opposed to the motion, and 2 members absent, Mr. Chair.
Great. Thank you, Karen. Okay, so while they're recording our votes, looks like the last bill we have on the agenda is LD 1284, an act to amend the Maine Clean Election Act and related laws. And that was the one from this morning, actually. We wanted to include that as this discussion today.
So this bill you heard this morning. So I don't have any information in this document on things that arose during the hearing, although there weren't many, I don't think, issues that did arise. So hopefully this is the information you need. So this is Representative Sekis's bill. It makes several changes to the Maine Clean Election Act. First, by changing the title to the Maine Publicly Financed Election Act, and then similarly changing the fund's name to the Maine Publicly Financed Election Fund. It also changes the amount of general fund dollars that are transferred annually to the fund from $3 million to $2 million. And those dollars, it says in the statute, are sales used in income tax revenues. And that's unchanged. It's just the amount from $3 million to $2 million annually that's changed. Like the bill you discussed earlier today, 921, this bill also eliminates the ability of gubernatorial candidates to receive funding under the act. The sponsor did explain that by eliminating gubernatorial candidates, he thought that that would justify the reduction in general fund money spent toward the fund each year. The next thing it does is it restricts candidates seeking to participate in the act to collecting seed money contributions from registered voters within the electoral division for the office they're seeking. And it clarifies that seed money reports must be filed by legislative candidates applying for certification under the act. That's kind of clear in one section of the law and not clear in the other, so it makes it clearer in the statute. It also eliminates the ability of certified candidates to obtain supplemental fund distributions by collecting additional qualifying contributions. So there would only be one distribution per election. So one for the primary, one for the general, one for the, depending on whether it's contested or uncontested, but you wouldn't be able to get additional monies if you collected additional qualifying contributions. It also changes the distribution amounts for certified candidates to match the amounts rounded to the nearest $500 that were established under the Act in 2014 before the Citizens Initiative passed in 2015. So it changes the distribution amounts that are available. It also clarifies in the provision we talked about earlier today that talks about the Commission's authority to adjust the distribution amounts based on the Consumer Price Index. The bill in Section 32 clarifies that the Commission can either maintain the amounts the same, increase them, or in fact reduce the amounts of fund distributions based on those changes to the Consumer Price Index. And then outside of the Clean Election Act, the bill makes two changes to Maine's campaign finance laws generally. The first is it amends, it repeals a provision of law that currently requires communications financed by independent expenditures to include a conspicuous statement listing the top 3 funders of the entity that made the independent expenditure. It also amends the section of law governing independent expenditures to specify that while party committees and political action committees that make independent expenditures do have to file reports with the Ethics Commission, individuals who make those independent expenditures would not be required to file such reports. And that's in Section 7 of the bill. Some additional information, I talked about the fact that the bill reduces the amount of general fund funding for the, it's no longer called the Clean Election Fund, but for that money that's available for certified candidates. It doesn't affect any of the other statutory sources of revenue for the fund. So it would still include all monies received through qualifying contributions. It would still include all revenue from the tax checkoff program any unspent seed money contributions or unspent fund distributions. So if a candidate finishes and has money and turns it back, that would all be a source of revenue, as well as voluntary donations to the fund. And then certain fines that are imposed for violations of the campaign finance laws are placed into that fund by statute. So the provision of the bill that, well, several provisions of the bill affect the distribution amounts. So first of all, gubernatorial candidates would no longer receive distributions under the fund. In addition, there'd no longer be any supplemental distributions available under the fund. So there'd just be one amount per race. And in addition, you would go back to the 2014 amounts before the 2015 Citizens Initiative. So if you look, if that, were to pass, then for a Senate candidate in an uncontested primary, they'd get $2,000. In a contested primary, that Senate candidate would get $7,500, as opposed to the numbers to the left are what they received in the 2020 election, or what they were eligible to receive in the 2020 election. It's actually an increase for an uncontested general election. If you look at what occurred in 2014 and round it to the nearest $500, the way the bill is drafted, they would get $7,000 for an uncontested general election if they're a Senate candidate, and $21,500 for a contested general election. And remember, under this bill, they would get no additional supplemental payments. So it'd be $2,100 max, $21,500 max. Similarly, for House candidates, there'd be no change in the amount for an uncontested primary. There'd be a reduction of $1,000 for a contested primary to $1,500. There'd be no change for an uncontested general election, but there would be a maximum payment of $4,500 for a contested general election for a House candidate. And again, no supplemental payments. And the amount of seed money contributions that the candidates can spend would not be changed by the bill. So those amounts are available. This chart, I think, suggests this is the only money, but there are those seed money contributions as well. So I stuck those in a little footnote to the chart. As far as the independent expenditures, some background there. Under current law, an independent expenditure is an expenditure made by a person, including a party, committee, or a PAC, that is neither a candidate contribution nor coordinated with or suggested by a candidate or the candidate's campaign, if that money funds one of the following communications: either a communication that expressly advocates the election or defeat of a candidate, or a communication that names or depicts a clearly identified candidate, and it's disseminated within 28 days of the primary, 35 days of a special election, or after Labor Day and before general election day for a general election. Those communications financed by any person are considered to be an independent expenditure unless the person who makes the expenditure is able to demonstrate to the Ethics Commission that even though there's a clearly identified candidate and it's within a certain time frame before the election, that communication wasn't actually intended to influence the candidate election. So if that showing is made, then it's not considered an independent expenditure. So under the independent expenditure statute, if you make an expenditure that meets that definition we just went over, and it's in excess of $250 during any one candidate's election, then you are required to file a report with the Ethics Commission. That report has to itemize each of your independent expenditures over $250, including the date and purpose of the expenditure and who it was paid to. And you also have to include a statement under oath with that report, swearing that the expenditure was not coordinated with the candidate, because remember, that's the essence of the definition of the independent expenditure. The Ethics Commission's website has guidance describing the types of covered communications that are funded by independent expenditures. They include palm cards, advertisements, phone banks, etc. But the independent expenditure statute says if the money is being spent on a telephone survey or a telephone call that might state the candidate's position on an issue, but isn't actually encouraging the person to vote for or against that candidate, or if the expenditures for a voter guide, those are specifically excluded from the definition of independent expenditure under the statute. So the money spent on those is not considered an independent expenditure that has to be reported to the Ethics Commission. The Ethics Commission also has some rules explaining all of those requirements that you can link to here. If you do link to it, look at section 10. So the bill, what it would do is remove the obligation of anyone who's not a party committee or a political action committee to file independent expenditure reports. So as the bill sponsor stated during the hearing, an individual who maybe at their house really likes a specific candidate and spends $300 buying a huge flag or banner to display on their property, they would not be considered to have an obligation to file an independent expenditure report under LD 1284, excuse me. The other thing the bill does is it repeals the top 3 funder disclosure requirement for independent expenditures. So that provision of law was also part of the 2015 Citizens Initiative, and it requires an entity that makes an independent expenditure. So not an individual, but an entity that does make the independent expenditure to fund a communication. They have to conspicuously disclose their top 3 funders in that communication. There are many nuances to this rule. So if a funder gave less than $1,000, they don't have to be disclosed. There are rules about what happens if 2 funders tie in the amount that they gave. There are rules about the font size and how long the disclosure has to be displayed if it's a video advertisement, for example. And all of those are set forth in the statute, which is linked here, and then also in the rules. And then there is some guidance posted by the Ethics Commission. If you want to look at that further, I found that very helpful in understanding what precisely the top 3 funder requirement entails. So that might be something helpful to look at. I did actually attach the statutes for this top 3 funder disclosure law, because like I said, there are many different things about how many seconds and the type and everything else. And all of that's set forth here so you can see what precisely would be repealed. Because as you know, when you look at a bill, it just says repeal and you can't see the language. So I wanted to let you see it. And then because I knew I would mumble over defining independent expenditures and make it seem very much more complicated than it really is, I did give you a copy of the independent expenditure statute there that you can look at if you want. I didn't have any technical issues with the way the bill's drafted. I think it does what it says it does, at least as far as I can see, and I didn't see any conflicts that it created with another law. And then we don't yet know the fiscal impact of 1284.
Great, thank you, Janet, and thank you for putting it together so quickly, knowing that we were going to be working all the other bills on this topic on the same day. Any questions on the analysis? Senator Hickman.
I actually don't have any questions on the analysis, but I do have a question for Director Wayne. So if that's not appropriate at this time, I will defer.
Yeah, no, it's great. Yeah, it's a definitely appropriate time for questions. Director Wayne, if you're, yeah.
Good afternoon, directors. Good to see you.
Good to see you. Thank you.
Thank you. I ought to know this, but I don't. Can a Maine Clean Election Act candidate pay for the design, printing, and publication of a piece of mail, but allow someone else to pay for the postage?
No, I think that would always not be allowed. I think the answer is a simple no, because that would be a contribution from the person who paid for the postage, to the candidate. And once the candidate is in the program, they can't accept either cash contributions or in-kind contributions. So I think that's a straightforward no. They can't do that.
That's what I thought. I just wanted to make sure that that was the case. That's all. Thank you.
Thank you.
Okay, other questions on this one? Chairman Chiazzo.
Thank you, Mr. Chair. In light of the fact that we just had this public hearing this morning and we've already tabled 2 of the other Maine Clean election bills, I move we table this bill.
Second.
Okay, a motion to table by Representative Chiazzo and seconded by Representative Wood. Okay, the motion is not debatable, so we will proceed to a roll call.
Senator Lucchini,
Yes.
Senator Lucchini, yes. Senator Hickman.
Yay.
Senator Hickman, yay. Senator Farren.
Yay.
Senator Farren, yay. Representative Chiazzo.
Yes.
Representative Chiazzo, yes. Representative McCray.
Yes.
Representative McCray, yes. Representative Tuttle.
Yes.
Representative Tuttle, yes. Representative Riley.
Yes.
Representative Riley, yes. Representative Supika.
Yes.
Representative Supika, yes. Representative Wood.
Yes.
Representative Wood, yes. Representative Kinney. Representative Kinney, absent. Representative Harrington.
Yes.
Representative Harrington, yes. Representative Corey.
Yes.
Representative Corey, yes. Representative Dolph.
Yes.
Representative Dolph, yes. 12 in favor of the motion, 0 opposed to the motion, and 1 member absent, Mr. Chair.
Great, thank you, Karen. So that will be tabled and will come up again in the future. So we'll give time too for people to kind of develop some language that will be ready to move some of these things by the time we bring it back. As Janet reminds me, we have about 50 bills on the table ready to vote. So we've got some work cut out for us in the weeks to come.
Well, Mr. Chair, it could always be 60.
Yep, it will be by the end of next week. Janet, do we have any other things that we need to cover today? We're good?
Not that I'm aware of.
Okay, thank you again for doing that one so quickly so we'd be able to see the points. That one was had a lot in it. So Representative McCray.
Thank you, Mr. Chair. It's been said before, but I can't resist saying, Janet, you're amazing. Thank you.
Second that.
She also
Heard that.
Should we embarrass Janet for a little while longer? Or? No, okay. I'm just kidding. All right. Well, thanks, everybody. We will see you all on Friday at 9. So with that, we will adjourn for the day.